I'd like to call the June 8, 2026 meeting of the Currituck County Board of Adjustment meeting to order. Madam Clerk, will you please call the roll?
Stephen Currituck,
Here.
Sam Miller, Kathy Bontemps,
Here.
Robin Kane,
Here.
Justin Hayslett,
Here.
Shay Balance.
Here.
Thank you, Madam. A quorum has been met with 5 members present. Are there any changes to the agenda? Do I have a motion to approve the agenda, please?
I so move.
All right. Motion to approve the agenda made by Robin. All in favor say aye. Aye. All opposed say nay.
Nay. Oh, sorry.
Make up your mind, Kathy.
Yeah,
That was unanimous.
yeah, right. Okay. Are there,
Who seconded the motion?
I'll second.
was that Justin, I think?
I think it was Justin.
Got it? All right. Are there any changes to the minutes from September 12th, 2024?
Not to my knowledge.
May I have a motion to approve the minutes?
I'll motion to approve the minutes.
I hear a second.
I'll second that.
Robin seconded. All in favor say aye.
Aye.
All opposed say nay. Motion is approved. In accordance with the State Government's Ethics Act, it is the duty of every board member to avoid conflicts of interest. Does any board member have any known conflict of interest with respect to any matters coming to the board tonight? If so, please identify the conflict and refrain from any participation in the particular matter involved.
No.
We have no conflicts. Thank you. Okay, Madam Clerk, would you like to perform the nominations and election of the chairman?
I believe the chairman can do that.
Okay. Okay, I'll accept any nominations for the chairman position.
I would like to nominate Stephen Currituck to serve again as chairman.
I'll second that.
I'll third that.
All right. Shay nominated, and we appreciate that. Thank you, Shay. All in favor of Stephen Currituck as chairman for the upcoming year, say aye.
Aye.
All opposed, say nay. Motion carries. Now may I have nominations for the election of the vice chairman? I'd like to nominate Shay Balance as vice chairman.
I'll second that. Third.
Okay, Stephen Currituck motioned for the election of vice chairman Balance. All in favor say aye.
Aye.
All opposed, nay. The motion carries. Thank you. And we won't have to change name tags, they're already there. All right, new business. Case BOA 26-03, Gavin, is it Kralik?
Yes, sir.
Pardon me?
It's Craig, yes.
Kralik, okay. Gavin Kralik, the applicant and property owner, is appealing a notice of violation, NOV, issued for the operation of 252 Tent at 2388 Tulls Creek Road in Moyock in Crawford Township. The notice of violation was issued based on staff's determination that the business does not comply with the home occupation standards of the Unified Development Ordinance, the UDO. Okay, anyone that is going to be appearing before the board here tonight needs to be sworn in if you're going to be speaking about this case, whether you're the applicant, the representatives, or any of the public who is going to speak. If you all could come up to the front and be sworn in. And you all will put your left hand on the Bible and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Okay, staff, are you guys ready to state the case?
Yes, we are. Good evening. I'm Megan Morgan. I represent the county. And I'm just going to do a brief roadmap of what the staff is going to show you tonight. I will have Jenny Turner. She is the planning director for Currituck County. And I will have Michelle Rogers. She's the code enforcement officer that was involved in the investigation of this case. And they will give you information on the property and the background of the property, the zoning district, the district purpose, and the use of the appellant and how that is similar to automobile repair and the like, and how automobile repair and the like is not permissible as a home occupation. So it's just a brief roadmap of what we're going to be talking about.
Thank you.
Mr. Schilling, do you want to defer any kind of opening comments to when you present? Okay, thank you. I will call Jenny Turner to the stand. Ms. Turner, can you introduce yourself for the record?
Yes, my name is Jenny Turner, and I am the Planning and Inspections Director for Currituck County.
How long have you been in that role?
I've been in the role since April 1st of this year.
And prior to being the planning director, what was your role in the county?
Prior to that, I was the Assistant Planning Director for a couple of years, and before that, a Senior Planner. I have 17 years of service in the Planning Department for Currituck County, or about 17.
Okay, thank you. And what are your typical roles and responsibilities in your job now as the planning director?
Administration of the Unified Development Ordinance, including interpretations and managing on the development application process that will include appeals, interpretations, in any kind of development application, rezonings, et cetera.
And what's your educational background?
I have a Bachelor of Science from North Carolina State University in business management, the minor in math.
And Mr. Chairman, the county would like to tender Ms. Turner as an expert witness in the interpretation of the Currituck County Unified Development Ordinance.
I
Accepted.
don't think you can be an expert on the interpretation of a statute. You can be an expert on what an automotive repair is, but I mean, how the statute is interpreted would be up to the Board of Adjustments, not to the witnesses who present to it.
And again, this isn't a statute, this is the Unified Development Ordinance.
An ordinance is a statute.
Am I correct in saying that the UDO is not a statute?
It's not
A manual.
a statute, it's an ordinance.
So, I think, so the ordinance is the local law that's applicable, that is enforced by North Carolina law. So, I guess I want to maybe better understand, so in terms of an expert in interpretation of the ordinance, of the UDO, I guess let me maybe better understand the objection and then maybe what you're tendering, the purpose of tendering her as an expert in the interpretation.
Okay.
It would be the equivalent of calling a witness in court on the ultimate question presented to the judge. You can't bring in a witness to say, this is a crime because I think it's a crime. Whether an interpretation of the law is the job of the quasi-judicial body before it's presented. So literally, they want to call her as an expert witness to say what you should find, which you can't call a witness to say that. Witnesses can testify as to facts. You can bring in an expert witness to help you understand or clarify something that you wouldn't be familiar with. So like if there was an engineering question, we might bring in an engineer to testify as to what you might not know about engineering. But as to ultimate conclusion as to what the ordinance says and how it's to be interpreted, that's the job of the Board of Adjustments, and you can't bring in a witness to tell you how you're supposed to interpret it.
Understood. So in regards to tendering her in terms of interpretation of this ordinance, are you tendering her as an expert in like planning and zoning based on her training and experience and I understand there's standard rules of interpretation and kind of her training and experience and maybe more of a broader spans of planning and zoning and one of those things obviously is the process of interpretation or reviewing a development application. Is that more
Yes,
the vein
I can
you're-
rephrase. So I would move to tender Ms. Turner as an expert in planning, zoning, and land use.
Okay.
No objection to that.
Okay, thank you.
There we
And
go.
then if you want to kind of go more in that
Yeah.
vein about how she went through that process, then we can go from there. Thank you. And Mr. Chair, are you acceptable with that?
I am acceptable with
Okay.
that.
Thank
Thank
you.
Thank
Thank you. Ms. Turner, can you give us a little bit of information? Are you familiar with the appeal application before the board tonight?
Yes.
Can you give a little bit of information regarding the background on the property itself?
Yes. So the property is located at 2388 Tolls Creek Road in Moyoc. The property is zoned single-family residential mainland. The property has a dwelling and an accessory structure on it. The single-family zoning district, single-family residential mainland, which is also referred to as SFM, has a district purpose of the ordinance.
And Ms. Turner, is that within the Unified Development Ordinance itself?
Yes.
What section of the ordinance is that in?
Point 4.2.
Okay. And may I approach the witness?
Yes, you may.
Okay, so is that the district purpose that you're referring to? I'm sorry, are you talking to Mike?
Yes.
Okay, hopefully there's enough copies. Is there enough copies? If not, that's fine, I can.
This one.
I have my ordinance too, if
Okay.
I'm sorry, I passed it down, it's fine.
Yeah, now we got that.
is that okay that I gave her
County
mine?
one.
Yeah, that's fine. County one, okay.
This will be Exhibit 1.
So Ms. Turner, can you tell us what that district purpose is for single-family residential mainland?
Sure. So the ordinance states that the SFM district is established to accommodate low-density residential neighborhoods and supporting uses on mainland Currituck County. The district is intended to accommodate residential development in ways that will not interfere with agricultural activity, interrupt scenic vistas from the Currituck Highway, or place undue stress on the county's educational infrastructure. A variety of residential use types are allowed in the district, including single-family detached homes, manufactured homes on their own lots, detached accessory dwelling units, as well as duplexes. The district accommodates agriculture, equestrian uses, minor utilities, as well as various neighborhood-supporting institutional uses, such as parks, open space, religious institutions, schools, and similar uses. Major utilities require approval of a special use permit, while commercial, office, and industrial uses are prohibited.
Thank you. In referring to the agenda packet on page, I think it's 37, I believe that is the appeal application. What is the appellant appealing exactly?
The appellant is appealing a notice of violation, and the grounds for appeal are in compliance with UDO Chapter 4, Section 4.3, subsection 4.3.3L, home occupation. 252 tent is not automotive repair.
Okay, and what exactly does the ordinance say about that?
So the ordinance, do you want me to read from that section of the ordinance about home occupations?
We can. And before you do, actually, let me share that with you all. And this will be Exhibit 2, County Exhibit 2. Okay, what is this?
These are the specific standards for home occupations, which are an accessory use permitted in the SFM zoning district.
And how does this relate to the appeal application tonight?
This is the section of the ordinance that was cited in the NOV, and the grounds for appeal are that the applicant is in compliance with this section, and that 252 tent is not automotive repair.
And how does automotive repair play into home occupation? Where are they getting that from?
So in the first paragraph there in home occupations under L, you can see that in the middle of the paragraph, it says home occupation does not include such businesses as automotive repair and the like.
Are there general standards in the UDO regarding accessory uses such as home occupations?
Yes, there are general standards that apply to accessory uses.
Do you have enough copies? Am I providing enough copies? Because I keep having an extra. Do you have?
We need one more.
Ms. Turner, can you go through what the applicable general standards would be in this scenario?
I'm going to object. I believe it's under Chapter 10 point, I'm doing this from memory, 10.3, when there are specific standards, they overrule the general standards. So the application of the general standards would not apply when there are specific standards set forth in 4.33L, where there are specific standards that are listed there 1 through 11 for home occupations. It overrules the general standards.
And within those general standards, it states that all accessory uses and accessory structures shall meet the following standards.
Unless there are specific standards that say otherwise. And there are specific standards regarding home occupations that say otherwise.
Is there a section in the accessory use section that states what you're stating, or?
It's in chapter, again, I'm doing from memory of the UDO, but
Sure.
in chapter 10, it talks about definitions, and whenever there's anything that's specific, it overrules the general, which is a general interpretation of statutory law. And when something says, generally you can't do this, but specifically you can't do that, the specific overrules the general. So whether or not this thing meets the standards of being a home occupation would be governed by these specific standards that are set forth in 4.33L. It would not be governed by the general standards that are under 4.32.
So, and if you want a second to look for 10, so I can put my eyes on it, because I too, I'm trying to flip through the ordinance to keep up with the copies that we're going, and I'm not trying to be difficult. I just want to make sure. So, my understanding with just any ordinance use, not this one particularly, just generally, is, and I say this only because I just want my board to make sure they're tracking along, to follow along with, to be following the proper legal standard, is that the ordinance has to be read in its entirety. And so when we have the maybe the more specific standards within a the use standards, that doesn't negate the kind of the umbrella that those more specific use standards are under. So it's like further defined. So if you want to find that section for me, it would be equivalent of a site plan, that there's standards in the ordinance that have a site plan, and those are broad.
broad strokes, and then you have specific development standards for a use that would be documented on a site plan. And so if I mean, maybe that's a better example of what I'm trying to convey in terms of that. And it may also be that you may just need to argue that if your
Right.
client meets those specific standards, that doesn't apply. But I don't know that it negates the presentation. But if you want to find it, I want to give you an opportunity to do that so I can look at it.
And I do agree that if there's specific standards that contradict the general standards, the specific standards would apply, but that's not the case here.
Oh, they're consistent, that's not,
They're consistent. Yeah, so the county argues that they're definitely consistent.
And if you want us to kind of keep going, if you get, we can wait, or if you want to keep going, we can
go
keep.
ahead.
Okay, and if you find it, or if you feel like it's getting to the other side, then we can revisit.
All right.
All right.
Ms. Turner, can you testify to the applicable general standards that apply here in this situation?
Yes, if I may, I'll start with the purpose part of this accessory use standards, that the section authorizes establishment of accessory uses that are incidental and customarily subordinate to principal uses. The purpose of this section is to allow a broad range of accessory uses so long as such uses are located on the same site as the principal use unless otherwise stated in specific standards, and so long as they comply with the standards set forth in this section in order to reduce potentially adverse impacts on surrounding lands. Then moving to the general standards under B, this is 4.3.2B, all accessory uses and accessory structures shall meet the following standards. And 1 is directly serve the principal use or structure, and 2 is be customarily accessory and clearly incidental and subordinate to the principal use and structure. 3 is be subordinate in area, extent, and purpose to the principal use or structure. Do you want me to read all these?
All the ones that are applicable, are those the only ones that are applicable? I think there's a couple more.
Right, so it goes on to say not exceed 25% of the heated floor or buildable area of the principal use except structures typically associated with single-family dwellings, garages, storage buildings, or were otherwise allowed by this ordinance. 5, be owned or operated by the same person as the principal use or structure. And then to an exception regarding vending machines. Be located on the same lot as the principal use or structure. 7, together with the principal use or structure, not violate the bulk density, parking, landscaping, or open space standards of this ordinance. And 8, not constitute a combination use, which is the combination of two principal uses.
I did find it. It's 10.11.
All right, give me
And
just
it's the following rules shall apply for construing or interpreting the terms and provisions of this ordinance. And under 10.11, under meanings and intent, when a specific section of these regulations gives a different meaning than the general definition provided, the specific section's meaning and application of the term shall control. So specific rules over general. And so since there's a specific definition of standards for home occupation.
to the extent they're not consistent.
Correct, and these are all consistent with the specific standards.
Well,
we should just
and
talk
I mean,
about-
that's the reason why we're here. So certainly, the county feels like the general use portion is applicable as in their interpretation, and you disagree, and you guys can argue about why you think it's consistent and why you think it's inconsistent, and the board can make their decision. So I think we can.
And this just goes to home occupation, like
Hang on,
generally.
I'm sorry, if you can just hold on.
Correct, we can overrule his objection on this, being that both sides are going to present evidence to their,
Yes, I think that, I mean, his objection was that I assume is not relevant because because of that section 10.11, okay. 10.11, and that provision I heard was to the exact wording I cannot recall, but to the extent that they conflict, that the more specific rule controls. And so it sounds like, based on his objection and the county's presentation, I think that's where we're going to be, is that we have diversion of what they believe applies, and what the applicant believes applies.
I disagree. If I understand the county's position correctly, to the extent that the general provisions contradict the specific ones, they're not valid. So really that would mean that the only question presented is whether or not there's compliance with the specific standards. So talking about whether or not there's compliance with the general standards is irrelevant.
Well,
Because to the extent that they're in conflict, the specific,
but there could be
When?
general standards that are not inconsistent with the specific standards. So they will not,
but if they're not inconsistent, then they would be consistent with the specific standards. And so if they meet the specific standards, then it seems to be a giant circle. We're talking about something that's irrelevant to the question presented, which is whether or not this meets the specific standards of what a home occupation is. And we can talk about it. To the extent that this is different than what you're going to actually rule on, I think the county's conceding that it's not relevant.
Am I correct in saying, Ms. Womble, that your vision of how general standards is like an umbrella and then specific standards are under this umbrella of what the general standards say? Is that what I heard you say earlier?
correct. So the way that the ordinance operates is that you have these general, it all kind of starts and funnels down, right? So you have these general provisions, these zoning districts, use categories. What are we allowed to do? What aren't we allowed to do? What are the, general standards for something, and then specific, then they get more specific as we get down into the weeds. And so, and Mr. Schilling is correct, is that when there's a conflict between the general standards or any standard and a more specific standard, the more specific standard controls. I don't agree that that negates entirely any consideration of general standards. It's to the extent that they're in conflict. And I think from what I hear, it sounds like the county and the applicant are in disagreement about what that looks like, and that's going to be kind of part of the crux of your decision. So I don't think that it bars the county from presenting this, but ultimately you're going to be faced with the decision of, does the general standard apply or does the specific standard apply, and what does this applicant meet? So I don't think it should not be barred from presentation, but it sounds like that's going to be a specific question
So
for
it
you.
sounds like his objection should be overruled in order to present both sides.
That would be my recommendation
That's what
at
I
this
would
time.
Okay, your objection is overruled. Thank you.
Okay, thank you, Mr. Chairman. I think we went through the general standards. Thank you, Ms. Turner. What is the use that is taking place on the property?
Well, the use is described by the applicant as 252 tent, which includes automotive tenting services.
Okay, and how does the county arrive at automobile repair services and the like, which is, as you mentioned before, precluded by home occupation standards?
Right, so home occupations are permitted, but they need to comply with this section of the ordinance as well as the accessory use standards that I read earlier that are relevant. And specifically, it calls out that such businesses as automobile repair and the like are not permitted as a home occupation. So in determining that, staff determined that the automobile tenting was similar, and the like portion of automotive repair.
And is there a provision of the ordinance that talks about, or you go through when there is a similar use, or to find out what's a similar use?
Right, so in chapter 10, there is a section that talks about interpreting unlisted uses as permitted.
2 pages each.
Bottom, I guess.
And I'd like to introduce this as county exhibit. What is this one? The 4. Okay. Ms. Turner, can you go through
Just it.
that section of the ordinance? Oh, whenever you're ready. Sorry.
10, 16. Okay, there's 2 pages.
Ms. Turner, can you go through that section of the ordinance and explain how the ordinance works with unlisted uses?
Yeah, so if a use is unlisted, there's this procedure in section 10.4.1D, interpretation of unlisted uses, that lays out the procedure for how the director may interpret a particular land use that's not expressly listed in the ordinance or in the use table, and lays out some standards that may be reviewed. So in part 2 here, the director shall, standards for interpreting unlisted uses as permitted. The director shall interpret an unlisted land use as permitted in a particular zoning district only after determining the nature, function, and duration of the use and the impact of allowing it in the zoning district are so similar to those of a use type or use category allowable in the zoning district that the unlisted use should be deemed allowable in the same manner as the similar use type or use category. In making such determination, the director shall consider the purpose and intent statements in this ordinance concerning the zoning district, the character of use types allowable in the district, and all relevant characteristics of the unlisted use, including but not limited to the following. And then it goes through the list of factors that may be considered. Do you want me to go through those?
Yes, can you go through those factors, the applicable ones?
Yeah, so there's the volume and type of sales, retail, wholesale, et cetera. The size and type of items sold and nature of inventory on the premises. Any processing done on the premises, including assembly, manufacturing, warehousing, shipping, distribution. Any dangerous, hazardous, toxic, or explosive materials used in the processing. The nature and location of storage and outdoor display of merchandise, whether enclosed, open, inside, or outside the principal building. Predominant types of items stored. The type, size, and nature of buildings and structures. The number and density of employees and customers per unit area of site in relation to business hours and employment shifts. Transportation requirements. Trip purposes and whether trip purposes can be shared by other use types on the site. Parking requirements, turnover and generation, ratio of the number of spaces required per activity area or unit area or activity. The amount and nature of any nuisances generated on the premises, including but not limited to noise, smoke, odor, glare, vibration, radiation, and fumes. Public utility requirements, impact on adjacent lands created by the proposed use type, which should not be greater than that of other use types allowed in the zoning district.
And which of those factors did staff look at in determining whether tinting was similar to automotive repair and the like?
So the volume and type, well, we looked at all of them, but the volume and type of sales, retail, wholesale, et cetera. This is a service use. The type of sale is a service. The volume appears to be relatively low on this particular site. The size and type of items sold and nature of inventory on the premises, that's again a service use where there's vehicles stored on the premises, probably not considered inventory. Any processing done, so the activity of tinting the windows of the vehicle, any dangerous, hazardous, toxic, or explosive materials, did not appear to be any of that here. The nature and location of storage and outdoor display, doesn't appear to be any outdoor storage or display. The type, size, and nature of buildings and structures, there is a large accessory structure behind the dwelling, and one of the bays apparently is used for the tinting. The number and density of employees, it's not clear whether there's additional employees that work on the site. Transportation requirements, that would be for just the vehicles to be transported to the site and off the site that are being serviced. Trip purposes, likely for this type of commercial use would be for tenting purposes and could be shared by other use types like a visitor to the site, a friend, may not be. Parking requirements, certainly there needs to be parking for vehicles that are going to be serviced. Nuisances generated on the premises, there could be some sort of nuisance with respect to odor. It's kind of unclear. No public utility requirements really that we speak of. And then the impact on adjacent lands created by the proposed use type, which would be similar to like, working on vehicles in a residential area, could be considered greater than that of other use types allowed in the SFM residential zoning district.
Okay, thank you.
I have a clarification. Ms. Turner, would you mind telling us the letters of those sections that you did use?
Oh.
I know
A, the volume and type of sales. B, the size and type of items sold. C, any processing. D, any dangerous, hazardous, or you just want the letters, sorry. E, F, G was unknown for this particular property. H, I, J, K, and M.
Thank you for that clarification.
And based on those factors, Ms. Turner, what did staff conclude?
We concluded that the use was similar to vehicle sales and service and automotive repair use. It was a similar use to automotive repair. Because it was service of vehicles.
Is there a specific section of the ordinance that talks about vehicle sales and services?
Yes, there's in chapter 10, there's commercial use classifications that include the vehicle sales and services light use type.
I have that, just gotta find it.
I'll give them back. I can't go through this.
And can you explain to the board what you looked at with that, what that ordinance states and how that assisted in your interpretation?
Yes, so this is section 10.4.5K, vehicle sales and services light. There's characteristics of this particular use category. Vehicle sales and services use light category includes types involving the direct sales and servicing of automobiles, motorcycles, light trucks. Accessory uses include offices, sales of parts, maintenance facilities, parking, outdoor display, and vehicle storage. There's example use types include automotive sales or rentals, light automotive repair and servicing such as oil changes, state vehicle inspections and muffler shops, automotive parts sales and maintenance, car wash and auto detailing, and tire sales and mounting services.
Okay, thank you. Now, I want to go back to the, so again, so with that, what determination did staff make with the window tinting use?
Well, auto tent was considered to be a vehicle service.
Okay. And going back to the home occupation standard, which I think was County Exhibit 2, maybe?
It's 2.
2. Are there any standards other than the exception of automotive repair and the like that is applicable here and would preclude this use as a legal home occupation?
Yes, there are the standards of the home occupation. For instance, 1, the business or services located within the dwelling or an associated accessory building and does not exceed 25% of the heated floor area of the principal structure or 1,000 square feet, whichever is less.
Is that factor applicable here?
Yes, because I believe that the bay that was used for this particular use is larger than 1,000 square feet.
Okay. Is there any other standards that may apply?
Yes, I mean, let's see. 6 is interesting because it says all vehicles used in connection with the home occupation are of a size and located on the premises in such a manner so as to not disrupt the quiet nature and visual quality of the neighborhood. And there are no more than one vehicle per home occupation. 7 is home occupation shall not result in regular and ongoing vehicular traffic to the home where located.
Are there any other standards?
It's unclear whether whether 11, there may be impacts from 11, that the home occupation does not create traffic or parking congestion, noise, vibration, odor, glare, fumes, or electrical or communications interference which can be detected by the normal senses off the premises, including visual or audible interference with radio or television reception.
Okay. Is there anything else that you can think of that we didn't go over that staff looked at in making the determination that window tinting is not a proper home occupation, is not an allowed home occupation?
We looked at the zoning, the overall character of the use in relation to uses that are permitted in the zoning district. On-site tinting does not appear to be customarily incidental and subordinate to a dwelling, and may exceed the scope of permitted accessory use home occupation. The activity resembles more of a commercial auto operation rather than a residential accessory activity. Home occupations are generally office use, very low impact, personal service type uses, like remote sales, or generally just an office type impact or personal service impact where the service is for the customer.
Okay. Okay, I have no further questions.
So the UDO in section 4.3L says that a home occupation shall be permitted as accessory to any principal dwelling unit, provided that the accessory use will not change the character of the residential neighborhood in terms of appearance, noise, odors, traffic, or other impacts. Is that your understanding?
That's that sentence, yes.
So when it says it shall be permitted, then you're supposed to allow it unless you find that the use will change the character of the residential neighborhood. Is that correct?
Unless there's other specific requirements that don't allow it.
Shall be permitted unless, provided that it will not change the character of the residential neighborhood in terms of appearance, noise, odors, traffic, or other impacts. Correct?
Not really, no. I mean, that's not the full, that is not correct, because you could potentially argue that a dentist office is very similar to a massage parlor with respect to impacts, but clearly that's not permitted. So no,
What
that
does
you have to read the
shall
whole
be-
section, you have to read the whole section together.
So what does shall be permitted mean?
It means it must be permitted, but that's not the end of that section.
So then it gives examples of what should or should not be permitted. And so as examples, for instance, it says that you can't have, as you pointed out, a dentist's office, but you can have a beauty parlor. Correct?
Correct.
How is this business different than a beauty parlor?
He's not, I don't think he's cutting hair.
Is there more traffic as a result?
I'm not sure if there would be more traffic necessarily, but
Well, the standards
the
here
work
are,
the work is happening on cars, not people.
so other than that, in terms of appearance, noise, odors, traffic, and other impacts, can you see a distinction between this business and a beauty parlor?
Probably when the garage door is up and you see the cars being pulled in and out of the garage, yes.
Versus someone pulling up and parking in a driveway and going in to get their hair cut?
Possibly, yes.
So you're focusing on the fact that it says automotive repair. Is automotive repair defined anywhere in the UDO?
It is defined in the UDO.
It's
It
in-
also says and the like, so similar to auto repair.
Does and the like mean the similar, or does it mean the same?
I mean, similar.
So anything similar to automotive repair is automotive repair?
Could be.
So what is the definition of automotive repair that's contained within the UDO? It's on page 10.42.
General repair, so the definition is actually automotive repair and servicing.
Right.
General repair, rebuilding, or reconditioning of engines, motor vehicles, or trailers, not including bodywork, framework, welding, and major painting service.
So under the definition of automotive repair that's contained within the UDO, bodywork, framework, welding, and major painting services are specifically excluded from that definition, correct?
Right, because
under
they're
your-
more intense uses.
But under
By
your,
definition of the classifications of the ordinance, they're more intense.
but the home occupation says it doesn't include automotive repair. So if it doesn't include things that are specifically excluded from automotive repair, your interpretation then would be that bodywork, framework, welding, and major painting services could be done as a home occupation.
Absolutely not, because I would use the ordinance like I have for this particular interpretation,
Because that would change the,
because that's vehicle sales and services heavy, not vehicle sales and services light. So there's categories, classifications, and use types of the ordinance and definitions.
that would change the character, wouldn't it? I mean, if you were doing something heavy, you're doing painting, if you're doing bodywork, if you're doing framework, that would not fit in a neighborhood.
I don't know how, well, I suppose there could be some off-site impacts from that, but you're still bringing cars for service, which is
I'm
very
agreeing
similar
with
to
you.
this
It
use.
would be inappropriate to put a body shop in a neighborhood, because that would change the character of the residential neighborhood.
I would think so, yes.
Yeah. So when we're looking at the statement that a home occupation shall be permitted, provided it doesn't change the character of the residential neighborhood, we wouldn't want body shops in a neighborhood, because that would alter the neighborhood in terms of appearance, in terms of noise, odors, traffic, and other impacts, right?
Appearance would be similar to any kind of automobile servicing, wouldn't it?
I'm not talking about his business, I'm talking about the things, a painting shop.
I'm just
a
talking in
framework shop.
general. Yeah, I mean, I think a body workshop would not be permitted.
So when we're talking about automotive repair and the like, we're talking, it's not the definition of automotive repair, which specifically excludes those things. What you're really focused on is whether or not the business, the home occupation, will have an adverse impact on the residential neighborhood, right?
Right, along with
And an
the
example of
certain
that.
uses that aren't permitted. So,
And looking at the specific following standards for a home occupation, you said, I believe the bay is larger than 1,000 square feet. Has anyone been out and measured the bay?
my understanding was there's staff here that has, not on site, no.
Okay,
But
so
there-
you're estimating the size of it.
Correct, our staff has estimated the size of it. I don't specifically know.
Do you know what portion of the bay is used for the business? It's a 3-bay garage, right?
My understanding is it's a 3-bay garage, correct?
So even if that one bay was larger than 1,000 square feet, that doesn't mean the entire bay is being used for the business, right?
Possibly.
Well, if what was needed, for instance, was a space to park a car, do you think that's more than 1,000 square feet?
No.
So space to park a car would be permitted under this.
I probably need more information.
Well, if it's less
Will it
than,
be less than 1,000 square feet? How big's the house? I don't know,
well, the lowest
right? Because
number.
there's 25%, yeah.
I know there's no evidence of
Yeah.
that here. So you said you thought it was more than 1,000 square feet, but
yeah.
but a parking space.
That's my understanding. It's actually in the agenda packet that our code enforcement officer put together, that said that,
Excuse me, you can't testify what other people told you. I'm asking you, do you
oh, I'm
know?
just telling you it's in the agenda packet. So no, I don't personally, I haven't personally measured the garage.
Do you know if anyone has?
I do not know. I know that no one has gone onto the site to measure the garage.
I don't know how they would have done that.
Yeah.
All right. Are you aware, you said any vehicles used in conjunction with the home occupation. Are you aware of any vehicles that are used in conjunction with this business?
Just the ones that are being serviced.
Those would be the customer's
I
vehicles.
mean, I believe the gentleman also has a vehicle where he does off-site work.
Okay, but the customer's vehicles would not be a vehicle owned by the business, right?
Correct?
Okay, so when it's talking about vehicles used in conjunction with the home occupation, those would be business vehicles, right?
Possibly, yeah.
Why? This is what you do. I mean, isn't that what that means? All vehicles used in connection with the home occupation? Those
Well,
would
it's
be
not,
business.
it's correct. It's not owned by the business.
It's not the
That's correct.
customer's vehicles that would count. It would be the business vehicles that would count under that, right?
Okay.
Am I correct on that? Used in connection with the occupation?
Yeah, I suppose so.
Okay. And so physical therapy, beauty parlors, pet grooming, presumably people bring their pets to a pet groomer, they go to the beauty parlor. You were talking about regular and ongoing vehicular traffic to the home where located. A certain amount of traffic is permitted, otherwise nobody would be able to bring their pets for pet grooming, nobody would be able to go to a beauty parlor, nobody would be able to go for physical therapy.
Agreed.
Okay. And I think you described it, the traffic is low.
I believe so.
And as far as the circumstances under number 11, you said it was unclear whether or not there was vibration, odor, glare, fumes, or electrical.
Yes, I'm not sure. I've not experienced any of these things. Our code enforcement officer can speak to
Just
that.
looking at the standards that are set forth under home occupations, you pointed to number 1, which was that it can't occupy more than 1,000 square feet, but you're not sure how much square foot it actually occupies, right?
Right, it was indicated that it was the one bay of the garage, yes.
But I mean, you were asked which of the standards under the specific standards, and you pointed number 1, and you said, I think it's larger than 1,000 square feet, but you don't know. Correct?
The bay is larger than 1,000 square feet. If you're saying that he's not using the whole bay for it, then maybe it's smaller.
Do you know how large the bay is?
No,
Okay, so you don't know on number 1, correct?
correct.
And then you pointed number 6, which was the number of vehicles used in connection with the home occupation. And you pointed to customers' vehicles, but you're agreeing with me now that that's not relevant, right?
Yes,
And on number 7, the amount of traffic is not unusual. In fact, you've described it as low.
right.
And you pointed to number 11, which you said was unclear.
Yes.
Which of the standards then, under home occupations, of the specific standards that you're supposed to look at, which one does 25210 violate?
It doesn't appear that it violates many of these standards, but there's the overall overarching what's allowed as a home occupation that it's violating.
I understand, but of the standards, is there any specific standard that it violates?
I would need to know specifically how big the area is where the service is located.
But as of now, the county has no information to provide to the Board of Adjustments as to the size of it.
No.
So you can't point to any specific standard that that 25210 violates, correct?
Correct.
So basically, the county's position comes entirely from the sentence that home occupation does not include businesses such as automotive repair and the like.
Correct, and that it's not customarily accessory and incidental to a dwelling, a vehicle services use.
And that's from the general. But the specific allows for, I mean, are beauty parlors customarily part of someone's house?
Yes,
Beauty parlors are customarily
they can,
part of.
they can be incidental to the house, for sure.
You just said going under the general standards, not the specific standards for home occupations. We look at whether or not it's customarily part of a house, right?
Sure,
But
yeah.
home occupations carves an exception to that and says that
Sure.
these are a specific standard. And it allows specifically physical therapy, beauty parlors, pet grooming, and the like. Those are things that are not customarily part of someone's house. Do you agree?
Sure,
So the customarily portion that you're relying isn't really applicable here when we're determining whether or not it's a home occupation, right?
it's still part of the ordinance.
But the general standard that says we are normally looking to see what is customarily done in a home doesn't apply if we're looking at the exception with specific standards for home occupations, correct?
Possibly, but you're also looking at the
okay to
specific
say
use of
yes.
automotive repair.
So the thing that the county is relying on is the sentence that home occupations does not include such businesses as automotive repair and the like. That's the county's entire case, correct?
That is a big part of it, yes.
What else is there? It doesn't violate any of the standards that you've described or that are laid out in the UDO. What is the rest of your position other than that sentence?
Just that, I guess it's just that sentence.
So the question is whether or not window tinting constitutes automotive repair. If it constitutes automotive repair, then it's not a home occupation. But if it doesn't constitute automotive repair, then it is a home occupation, right?
You mean it's an allowable home occupation? Yes,
And so,
possibly, yeah, if it meets everything else.
I mean, it
I
seems
mean, there's
like
volume, there's lots of things that go into it.
all of the specific standards that
Sure.
are listed for a home occupation, it meets to the best of your knowledge. Yes?
Yes,
So isn't this kind of a circular thing? You don't know if it's an automotive repair. But if I do find it is an automotive repair, then it can't be a home occupation. So there we find is an automotive repair, so it's not a home occupation. But if I find that it isn't an automotive repair, then it can be a home occupation. It's sort of
Sure.
what you get to decide what it is. But automotive repair, as defined in the UDO, specifically says that would not include bodywork, framework, welding, or major painting service. So, just following your reasoning, if the use of the words automotive repair is what determines whether or not something's a home occupation, I can have as a home occupation a framework business or a welding business or major painting.
no, we already went over that.
Right, but
We said it's automotive repair and the like,
Right.
it's similar.
that's
Just
not-
because it's a different use category, those uses.
But in the UDO, automotive painting and body shop has a separate definition in the UDO, doesn't it?
Yes,
So that would indicate it's not the like. Automotive painting and body shop is defined as one thing. And this is on page 10.42 of the UDO, under 10.5 definitions. Automotive painting and body shops are defined as one thing. Automotive sales and rentals are defined as another thing. Automotive repair and servicing are defined as a third thing. So they wouldn't be the like. These are three separate categories, right?
and automotive parts and installation are defined as well, but they are similar.
But they have separate definitions. They mean different things. They are specifically given separate definitions within the ordinance, right?
Yes,
So when another portion of the ordinance talks about specifically automotive repair, and automotive repair is defined in the ordinance, doesn't that mean that the ordinance is limited by the definition that it contains within itself?
and the like. You're
So the
ignoring
definitions
those
are
three
meaningless?
words. You're ignoring those three words and the like.
So automotive sales are the same, are similar to? Is it the word automotive? Is that the key? As long as it involves cars?
No, not
Can't have
necessarily.
can't have an home occupation that involves cars? I mean, there seems to be a difference in the definitions between sales and rentals, racing, parts and installation, painting and body shop work, and repair and servicing. There's 5 separate definitions for those things, so they appear to be different things according to the UDO, which would mean that they're not and the like. Wouldn't it?
Possibly, but what, is automotive tinting one of those things that's not in the like?
And then that, I guess that's the question presented. So really what it boils down to is that a home occupation, if I read this correctly, shall be permitted as accessory to any principal dwelling unit, provided that the accessory use will not change the character of the residential neighborhood in terms of appearance, noise, odors, traffics, or other impacts. Does 252 tint change the nature or characteristic of its residential neighborhood in which it's located in terms of appearance? Does it?
I'm not sure.
Well, the building was there before 252 occupied it, right?
Sure, the building was, yeah. But the use occupies
Not
more
as-
than just the building.
And does it change the character of the neighborhood in terms of its appearance?
The building, no, the building was there,
Are there any signs up?
not to my knowledge.
So it looks exactly the same as it looked before the business was there, correct?
The buildings do, yes.
Is there any noise that you're aware of from applying stickers?
I'm not aware of any noise to speak of,
Are there any odors that you're aware of?
minimal.
Is there, and the traffic you described is low, right?
My understanding is it's low.
Or other impacts, any other impacts that you know of on the character of the residential neighborhood?
Potentially parking of vehicles to be serviced. But it's not service, or is it?
Vehicle service, you relied on the vehicle service section, but vehicle service is not contained within, there's no, the words vehicle service are not located anywhere within the definition of home occupations, are they?
Right, it's automotive
Automotive repair and the like.
And
so-
servicing is part of the definition of automotive repair, though.
And yet, I didn't put servicing in home occupations. You didn't write it, I get it.
Yeah.
So, but ultimately, would you agree with me that when they wrote this section, they were giving examples of things that don't interfere with the character of the neighborhood, such as beauty parlors, pet grooming, physical therapy, but that things like a tattoo parlor, a social club, a restaurant, or bar, those would interfere with the residential neighborhood, correct?
Sure, those are some examples.
So would you agree with me, the way this is written is to say you should grant it as long as it doesn't change the character of the residential neighborhood in terms of appearance, noise, odors, traffic, and other impacts? Examples of that would be, it's okay to have a beauty parlor or pet shop. It's not okay to have acupuncture, tattooing, body piercing, animal kennels, or hospitals, which are all listed in this statute.
Right, so it's saying what's permitted and what's not permitted.
But if it's a list of what is permitted and what's not permitted, and it lists automotive repair and the like, do you think it's limited to just that? It's just these things that are permitted and just these things that are not?
No.
Okay, so these are examples.
Yes.
supposed to be a
Well, they're
guide for
examples,
you.
but they're also exclusions of
They're
certain
supposed-
specific uses.
There's supposed to be a guide for the county to use to determine what does change the character of the neighborhood, right? When you go to a automotive repair shop, aren't there usually a lot of cars kind of parked around the house?
There
Or
can
around the
be.
shop?
There can be, yes.
A lot of noise? People using air wrenches and mechanics banging on things?
Sure, there's noise associated with that use.
And they're rarely working on just one car at a time. There's a bunch of cars waiting. There's sometimes junk cars kind of piled up outside. You've seen that at car repair shops before,
Yes.
right? Does anything about 252 tint suggest it's anything like that?
I've just seen pictures of the cars parked in the driveway area and in the bay.
So there's cars parked in the driveway and there's car parked in the, how many cars did you see parked in the driveway?
Just saw pictures from the enforcement.
One car?
I'm not sure.
I mean, any indication there's multiple cars parked, junk cars out in the parking lot,
There's
out
no,
in the grass?
I didn't notice any junk cars in any of the pictures.
I don't think I have any other questions.
I have some redirect, Chair, thank you. Ms. Turner, Mr. Schilling kept harping on the home occupation shall be permitted and kept reading that first sentence of home occupation. But when you're interpreting an ordinance, do you just look at one provision or do you have to look at the whole?
We generally look at the whole, any sections that are, or standards that apply when making a determination.
And also, Mr. Schilling mentioned the other definitions in 10.5, automobile servicing, painting, all of that. Are those all listed in the use table under the vehicle sales and services light?
Let me look.
Here, I have a copy.
So automotive painting body shop is not specifically listed that I see. Automotive parts and installation is listed. Automotive sales or rentals are listed in the light section. Automotive racing, was that one of the ones you asked me about?
So would you just list off what that group of what's in vehicle sales and services light? I think that'd be more helpful.
Yes, automotive parts and installation, automotive repair and servicing, including painting and body work, automobile sales or rentals, car wash or auto detailing, taxi cab service.
So in this category, when it talks about automobile repair and servicing, it includes painting and body work.
Correct.
Okay. And so the use is window tinting, what other use do you think that would be similar to if it wasn't automotive repair and the like? I mean, is there any others that you can think of since window tinting is not a listed use?
That would most closely fit, would most closely fit an automobile repair and servicing use. You could potentially say that it's similar to automotive parts and installation, but that is defined as on-site sale and subsequent installation of various automobile parts and accessories.
Would that, let's say it's that, would your opinion change about it being and the like with automotive repair?
No.
Okay. And there was a few questions that you just didn't know the answer to, like the 1,000 square feet, the vehicles. Is there county staff that does have some personal knowledge of some of those questions, of some of that information?
Objection, hearsay.
How is it hearsay for her to say if there's county staff that
Oh.
she supervises who has this information?
Fair enough.
Okay.
Can't share what the information is.
That's fine.
Overruled.
My understanding is that we do have county staff.
Okay, thank you. No more questions.
All right, so the board?
I have a question, at least one, Ms. Turner. On the home occupation section L, number 6. This talks about the vehicles used in connection with the home occupation. Am I correct in saying that is speaking of the home occupation's owner, not the folks who are getting work done?
Yeah, that's what
That's speaking
Mr.
mainly
Schilling was
about
asking me about. Yes.
having 2 or 3 vehicles that are for the business that are owned by the occupant.
Correct.
So that's not talking at all about who comes to be serviced in this case.
Right.
Ms. Turner, can you direct us to how many square feet was thought to be of one particular bay that the work was being performed in? It was 12 something, I
On
think.
page 6 of 38 of the staff report, the agenda packet, the bullet that says June 2nd, 2025 states that Gavin Kralik came in and spoke with staff about the violation. Gavin stated the business is a 50-50 split between automotive tinting and business tinting. At most, there would be a maximum of 4 customers coming to the shop a day, and everything is done inside. There was one bay set aside to do the work, approximately 1,289 square feet.
Ms. Turner, do you know how that square footage measurement was calculated?
No.
Do you know the total square footage of the entire structure?
I do not.
Okay.
Off the website, it's 3,750 square feet for the garage area alone. The house is 1,221.
You said 3,750? Approximately.
It's a huge garage.
So just so I'm clear, you said that was from where?
From the county's website, when you look up the PIN number, accessory buildings, it came up as 3,750 square feet garage, detached garage.
Is tax records, is that the tax records?
Yeah. And then the house is 1,221 square feet.
Does any other board members have any questions for Ms. Turner? Anyone else have questions?
I do, yeah. Concerning the evidence that's provided in the packet, I don't know if this is appropriate for this part of the process, but from the pictures, how can you determine what's personal use and what's not personal use to the homeowner?
I have to defer that question to our code enforcement officer.
Okay. Following question concerning the evidence collection. Was that verified? And by who? What third party took those pictures? Is there a chain of custody? Is there any metadata attached to that?
I'm not sure about the metadata. Again, our
Is-
code enforcement officer prepared this, so
AI is a thing, that's all I'm saying. So, but that's all I have.
That's a good question for later.
Is there any other board members?
I have a quick question. Ms. Turner, you were likening this to,
Get up to the mic a little bit more.
sorry. You were likening this to automotive repair. Would you also liken it to, in any way, car wash or auto detailing?
you could liken it to that. I mean, it's in the sense that it's service to a vehicle,
Right. Thank you.
but that's not installation of
Right.
additional parts or servicing.
Is car wash and auto detailing allowed? In a
I
single
don't
family?
believe so, no.
Okay, that's all I have. Thank you.
Okay.
Anything else?
Mr. Turner, it appears that, and correct me if I'm wrong in this, that automotive tinting is not specifically covered in any of the ordinance, but it has been, the ordinance has been interpreted to include auto tinting, is that correct?
So the automotive repair and the like has been interpreted to include auto tinting,
Okay. So it's an interpretation made by staff.
yes.
Okay.
If it wasn't automotive, if it was some other business that he was doing in that bay, it still wouldn't be allowed because it's still not conforming to the square footage, correct?
If the area was too large, that would be the case, yes.
Right? Okay.
I would only object to note that there's no evidence of how much is actually being used.
I'm sorry?
There's no evidence of how much of the bay is actually being used.
Correct. But he admitted, he stated he was using 1,289 square feet.
No, he did not. That's not what that says.
Where did you
Isn't
see
it?
that?
It's page.
Where'd it go? That's what he said that he used.
Page
with
6,
the-
bullet point, June 2nd.
I mean, he'll be testifying about it in a moment, but he didn't measure.
Yeah, he says there's one bay set aside, approximately 1,289
Yeah, that
square
was his
feet.
statement.
So, yeah.
Gavin Krellick.
If I may suggest, he said he used one bay, and then someone did what you did, which was took the total square measurement of the building and divided by 3 and came up with that.
Well, I
number.
think we can get to that. I think right now, as it sits before the board, he asked about that line, and that line has been read. And so as the board sees it right this minute, that they understand that to be his statement, and you can certainly come back and discuss that in more detail. So,
Okay.
any more questions for Ms. Turner? All right. Thank you.
Thank you, Ms. Turner.
The county calls Michelle Rogers to the stand. Ms. Rogers, can you state your name for the record?
My name is Michelle Rogers, and I'm the
Yeah, what is
Currituck
your
County-
job here with the county?
I'm the Currituck County Code Enforcement Officer.
And how long have you been the county code enforcement officer?
I've been in this position for about almost 4 years in November.
And in your role as the county code enforcement officer, are you familiar with this case that we're talking about tonight?
Yes, this property is located in my zone, so I was the code enforcement officer that was responsible for the investigation.
Okay. And what is the property address, if you recall?
The property is located at 2388 Tolls Creek Road in Moyock.
And do you know what zoning district the property is located in?
Yes, it's in the single-family mainland residential.
And how did this case come before you to begin with?
Well, initially, because the appeal that the applicant has put in is actually the second notice of violation on the property. The initial one came in May of 2025. We received an anonymous complaint. They stated that an automotive repair shop was being operated out of the garage. I performed my inspection, but I was unable to determine at that time what was going on in regards to whether or not an automotive repair shop was being operated. I utilized social media and identified some photographs which pointed to the property being utilized for the business identified as 252 Tent.
And are those pictures in the agenda packet?
Yes, those pictures are pictures 1, 2, and 3.
Do you know what page, is that page, okay. What page of the agenda packet?
So picture 1 and 2 are on page 9, and picture 3 is on page 10.
Okay. And this was in regards to that first notice of violation?
Yes, that was in regards to the first complaint I received. Since I wasn't able to visually identify, I utilized that social media. You can see by on one of the pictures, you can actually see the windows to the roll-down garage that are in particular that you can see on picture 4 on page 11. And that's how I came to that conclusion that that was being operated out of that particular building.
And what happened with that first notice of violation?
I sent out the notice of violation. I received a call from the applicant. Approximately two days later or so, the gentleman came in, spoke with 3 of our planners that were on site at that time. Their names are in this packet, but I will identify them as Jason Littoral, Patrick Leary, and Millicent Orr. He provided us the necessary information about what he was doing on the property. And as we just addressed a few minutes ago, he did explain that it was a 50-50 split, that he was only operating out of one of those bays. This approximate square footage that you all have in your packet, that did come from me based on his, telling us that one bay was being utilized for that particular application of the tent.
Where did you get the specific number, the 1,289 square feet?
This specific one I took from GIS. I did a calculation using those parameters on GIS, just so that I would have that, as well as, granted, I didn't put it in here, but as you addressed earlier, from the property records, it gave us the square footage of the entire building, in which you could then, divide by 3 and come up with 1,250 square feet for the whole entire building. Mine was just an approximation.
Have you personally been on this property?
I haven't.
Have you personally seen this property?
Yes, and I have driven down the driveway, but I have not gone any further, whether to inspect the inside or anything along those lines.
Based on where you've been and looking at the property, based on your personal knowledge, were you able to see if those bays were a third of the entire garage? Just from like a naked eye?
From a naked eye, or several pictures that may not be in this particular packet, but were in with the actual complaint, to where you could see inside, where I had taken pictures from a right-of-way off of Brick Court. I guess you could identify that at that way.
Okay. So, so the first notice of violation, it sounds like you marked it as complied. Can you talk some about this violation in particular that was being appealed, and summarize for us your investigation and what's kind of listed in the staff report here?
Okay. So after the first notice of violation was marked complied, that was based on an email. Once we received, and the planners had, researched the UDO, determined that what the use occurring on the property was not allowed as a home occupation. I sent an email to Mr. Currituck. He responded back that he had gotten that email, and that email, he was told that that was not allowed on that particular property. But then several months later, we received a complaint from the neighbor stating unusual smells, noise, and additional work possibly being done on boats. So I reached out to Mr. Currituck, who I had, previous email workings with. And he said that no business was being operated on the property. That was addressed in an email as well. But at the beginning of the new year, the Board of Commissioners received a letter requesting that I go out, that the business was still operating on site. So I went out to do my investigation. I, again, could not find anything right away on the site, so I went to social media, and I was able to find 11 snapshots from Instagram with a note saying, took a break from posting on here, someone keeps reporting me. Those pictures are pictures 5 through 15, identifying, again, vehicles that have been tinted by Mr. Kralik.
And the emails that you referred to earlier, are they also in the agenda packet?
Yes,
Okay.
those are also in the packet as attachments as well, to identify not only my email to Mr. Kralik, but his response to me.
I'm just going to object to the relevance to those as to whether or not this is a home occupation. The only issue that should be presented to the Board of Adjustments is whether or not this is a home occupation or not, because that's the only thing, as noted, that's on appeal. If it's a home occupation, it's a home occupation. If it's not, it's not. That's really the only thing. So this string of emails and the conversations back and forth really don't address that question, so they're not really relevant to that in any way.
I would say they're completely relevant. They're communications between county staff and the appellant, and it's all in regards to the matter before us tonight.
He's not disputing that he's tinting cars in that garage. I mean, that's,
What is your opinion, legal opinion about communications in our office?
So my understanding is these are communications between the applicant. He's objecting to the communications between the applicant and staff. And staff is investigating the complaint and the alleged use. And, you know, I guess
for what purpose
that
are they
those
being-
facts were utilized in Ms. Turner's, purportedly utilized in Ms. Turner's interpretation of this use being defined as vehicles, automotive repair and the like. And so to the extent that this is code enforcement talking about their investigation, which led to the NOV and the facts to support the interpretation, I would disagree that it's not relevant, but you can certainly argue.
Well, for instance, the email from a neighbor to the Board of Commissioners, I'm not sure what relevance that would have as to whether or not this is a home occupation. And he's not here to be cross-examined, and so that shouldn't come in. And again.
So
the-
are you offering the email from the neighbor for the truth of the matter asserted
No.
or to explain her next steps?
That's we're going through the investigation and how she arrived at her
Okay,
conclusion.
so to the board should not consider the email from the neighbor as facts. That should just be considered as this is
Part of the evidence.
part of what prompted staff to engage in their investigation. It should not be considered as,
We'll
And can you
stipulate that
repeat your
they,
objection for me?
sure, I'll stipulate that he's tinting in the garage, and I'll stipulate there was an investigation. How we got to that point is irrelevant to what's presented to you. You just need to determine, is this a home occupation or not? Could we just limit the testimony to things that are relevant to whether or not it's a home occupation?
Is
I
that
think-
is that agreeable to
N-
staff?
Absolutely not. The investigation is completely relevant to how county staff came up with its determination that tinting is similar to automotive repair and the like. The facts of the investigation and everything that Ms. Rogers witnessed and saw, that is completely relevant. I don't know how you would even come up with that interpretation without these facts.
Okay, your motion is overruled.
I have no objection to her testifying to what she saw. I'm just saying, like, the whole story, background, who complained, and how we got here. If she just wants to tell us what she saw and the facts that are relevant, we could just focus on that.
Which is exactly what she's doing.
I believe that is a part of it, you know. There may be some things that you hear tonight that you're not gonna like, that comes from staff and/or the other employees. But I would say we need to hear this and continue with objections if you see fit, and we'll decide on them when you make them. Okay, go ahead, staff.
Okay. Well,
Might be helpful. Re-ask your question. I think we had a kind of a big pause there.
Yeah.
Yeah, I'm trying to recall what my question even was at this point. I think it involved your investigation with it. What else is relevant here regarding your investigation that would be helpful to the board?
okay. So in regards to the second notice of violation, so we did get a report that the business was still operating. Was not able to determine just by going out doing a cursory inspection. So I went to social media, found posts on there that identified that the business was still operating on site. Then I performed over approximately a month period, 6 cursory inspections done at different periods during the day, not always at the same time, sometime morning, lunch, late afternoon, to determine how many vehicles may be coming onto the property, leaving the property, and try to identify that there was vehicular traffic that was coming onto the property. Once I was able to do that, and again, obviously using social media, I issued that second notice of violation for the home occupation.
And in your conversations with Mr. Kralik, has he ever disputed that he's running a business, the window tinting business, out of that garage?
After that second notice of violation was issued,
Again, we'll stipulate he operates the tinting out of the garage.
And that's what I was kind of getting to. So has he ever disputed that?
he did dispute it in our office. He did come in to talk about this other complaint that had come in from the neighbor. I had asked him if he was still operating. I referenced those items that were in that Instagram post. Again, I'm sure you might hearsay. He said that he had posted those because he knew that the neighbor was looking at those particular type of social media things. So.
Okay, thank you. Is there anything else that you witnessed or observed in your investigation?
Well, I myself did. I actually see a vehicle that went in and approximately an hour and a half later went back out with a nice new tint. That was the only time that I ever saw an actual vehicle other than from videos that I reviewed that we had received from the neighbor in regards to the activities that were going on.
Do you know approximately when that was?
That was on April 9th. I had left here to go to lunch. I saw a white Camaro looking a little lost in Currituck. They had a Virginia plate. They pulled into Mr. Kralik's driveway. I went around to Gregg Court, got a picture of the gentleman who had parked his Camaro there and was walking in the side door. The Camaro was not tinted at that time. I went to lunch. Just so happened as I was coming back from lunch, the gentleman was pulling out. For whatever reason, he was at Gregg Court. He was pulling out of there and going up towards Currituck Highway on Tolls Creek. I followed him and took pictures while I was at the light, as well as while I was behind him.
And the notice of violation, is that in the packet?
Yes, that notice of violation is attachment 6.
Okay. Is there anything else that would be helpful for the board that we haven't discussed already? Anything else you can think of?
Not that I can think of.
Okay. And I would like to introduce the entire packet into evidence as Exhibit 7. And I have no further questions from Ms. Rogers.
Well, all of the emails that would be from the county are self-serving hearsay, so they're inadmissible. You can't introduce statements from yourself. The only thing that would be admissible would be the photographs and the statements that Mr. Kralik made. You can't introduce, the county can't introduce statements made from county officials writing to somebody else. That's self-serving here. You create evidence by sending an email out to somebody and then introduce that email.
An email to the applicant?
Correct.
Which document are you talking about specifically? This is
There are
confusing.
emails from Ms. Rogers to Mr. Kralik.
And Ms. Rogers is here subject to cross-examination. I don't see how that is hearsay.
The email is self-serving hearsay. This is like first-year law school stuff. You can't introduce emails that you create. She represents the county. County's sending the emails. You can't send emails that the county created as evidence to support the county's position.
So,
Seriously, like evidence
there-
101.
well, okay, I appreciate the law school education, but for purposes of tonight's hearing, I'd like to focus on the agenda packet and the emails. And so are you contending that the emails, what page of the agenda packet is your objection related
Page
to?
24, page 25, page 26. Page 27 is a snapshot from Google reviews, so I don't even know if that person's not here, and that's hearsay. You can introduce the notice of violations. There's a chart of some sort on pages 30 through 38 that has no description.
All right, so let's go a page at a time just so we can address that and the record is clear. So in regards to the emails from the county, she testified that she sent this email. It can be used as corroboration that she sent the email. I
It's an
have
out-of-court.
to, it's an out-of-court statement by the officer who is sitting here.
Which is the definition of self-serving hearsay, which is specifically excluded under the rules of evidence. You can't create evidence by sending someone an email and then introducing the email that you sent.
Well,
It's being offered for the truth of the matter.
I guess I don't agree. So, and I guess I could be wrong, and that's fine, but I don't agree with that assessment. I do think that staff can introduce the emails that they sent to an applicant throughout their process of an investigation of a complaint and enforcement of the ordinance, and that is not unauthorized hearsay. In addition to that, there's an exception, which is corroboration to support the fact that she did what she said she did. And so I don't think that those should be excluded, but we can certainly note those objections for the record. And then you noted that we already addressed page 26, which was the letter from the neighbor to the Board of Commissioners, which is that's not offered for the truth of the matter, sir. The board should not consider those facts as facts.
What's
And
being introduced for?
to explain how she became engaged in the second complaint is what I heard, the testimony.
How is that relevant to whether or not this is a home occupation?
Because she can explain how the complaint came in, which is how we get to even the determination of home occupation. And then, of course, the Google review, I think she testified that she reviewed social media, and I don't, in regards to the truth of the matter asserted, you know, I guess if you want to, page 27, the Google review, the only thing I heard testimony about was Instagram. And she said she talked to the applicant about the Instagram post and he acknowledged those. So the Google review, I don't recall hearing anything about. Do you have a position about that objection or?
That also, and I can, Ms. Rogers, did you review the Google review as part of your investigation?
And if she did, it would be seeing somebody else's out-of-court testimony who's not here to be cross-examined. This is
I agree.
literally
I agree.
hearsay.
I agree.
And
I
we're
agree.
not offering it for the truth of the matter asserted, what this Brian Smith is stating. We're just offering it as what Ms. Rogers looked at and making her determination as part of her investigation.
You can't introduce a bunch of inadmissible stuff by saying I'm not introducing it for the truth of the matter, which is what they're trying to do. So it has to have a purpose. You can't just introduce it because I feel like it. I want to introduce this to explain.
So I don't think that, okay, hold on. Page 27, the Google review, I believe that Miss, I'm sorry, what's your last name?
Rogers.
Thank you. I believe Ms. Rogers already testified specifically that she used social media to determine, to see if she could find pictures of this business operating there. Additionally, she did not testify about Google. I do not think that there's any purpose for the Google review in addition to her testimony that is necessary, so we should strike page 27 because there is no other purpose. And then she's already addressed the Instagram post. And in addition to that, Mr. Schilling said his client stipulates that the business is operating. So we should strike page 27. Do you have an objection to any other page of the agenda packet?
Pages 30 through 38.
And I guess maybe, Ms. Morgan, you can address that. I understood that to be, was that,
Yeah,
I don't want to speak what I understood it to be. Do you want to address page, is 30 through 38 the spreadsheet? Okay.
yes, I believe page 30 through 36 is a spreadsheet. I mean, I can ask Ms. Rogers. I would like to.
If you're trying to introduce it, I think there needs to be a better foundation laid about
Yeah.
what it is, where it came from, who prepared it, what information was used to prepare it.
And it's my understanding that she prepared this with information that she does not have personal knowledge of. So the county is fine with not introducing that into evidence with the agenda packet.
Okay, is that right, Ms. Rogers?
Correct.
Okay, so then page 30,
Okay, Ms. Walmel, do we need to go ahead and rule on his objection
that's what
to
we're
the
doing.
other? I
We're
mean,
working through the pages.
prior to that, yeah.
Yep, so I guess it'll be sustained in part and overruled in part, and it's in regards to these specific pages.
I thought they had to decide that.
I was giving him my recommendation, like I have done earlier. So in regards to, so the county made a motion to identify and admit the agenda packet as County 7, is that right? 7 in its entirety, and he objected. And his objection began with the county emails, the emails that county staff has on page 24 and 25. And the board will have to make a ruling on that. It's my recommendation that those are not in violation of the hearsay rules. And he's made his objection, and you have to decide which direction you want to go, to allow those as part of the record or not.
In my opinion, overrule pages 24 and 25. I believe they should be in the record. Should.
Yep.
And we were going to strike page 27.
Well, 26 is the letter to the commissioners, and just will note that that is not being offered for the truth of the matter asserted, and it's not facts. Anything you read in there should not be, if it's in conflict to the evidence that has been presented to you tonight, you can only consider the evidence that was presented to you tonight.
So sustained on page 26 and 27. We realize 26 is not a fact, and 27, we were going to strike that page.
Correct. And then he also objected to page 30. through 36, which is what we were covering last, which is what
Okay.
we agreed that we did not have any information about where that came from.
Okay. Can we overrule that one temporarily, the 30 through 36?
County's
Well, county
withdrawn.
just stipulated.
Until
County
we
stip-
get the foundation?
Well, that was, I requested the foundation.
Okay.
And the county stipulated that spreadsheet was prepared from information she does not have personal knowledge of. And
We
I,
should not consider that.
unless the county's calling another witness.
No,
Then-
we stipulate to striking 30 through 36
Okay.
from the
Not another
record.
witness to
Okay.
support that information.
In
Then
that case, then it's sustained on 30 through 36. Striking those pages.
And I think that covers,
there.
there's the appeal application, it goes to the end of page 38. Right, so that would, Shuri, for the record, that would be admitted as 7 with those modifications. All right, so
And I
you're,
had no further questions for Ms. Rogers.
Mr. Schilling.
So, I mean, you've never been inside the garage at all?
No. The last time that Gavin was in the office, he did offer it. But
In one bay?
he offered that I could go tour to look inside, but I did not.
1,000 square feet, correct me if I'm wrong, my math's wrong on that. That would be a space that's 20 feet wide and 50 feet long. Is that right?
I don't know. I'm not a planner, so I don't really deal with those kind of numbers all the time.
You'd agree 50 times 20 is 1,000?
I would agree.
So, you know any cars that are 50 feet long?
I'm sure there might be some vehicles, but not any normal, regular vehicle.
I mean, would it make sense that there's a space inside that garage that's greater than 1,000 square feet where a vehicle's being parked? It would have to be over 20 feet wide or over 50 feet long, right?
Again, that's not my expertise or my forte. I don't go into any of that.
You repeatedly investigated this and you drove by randomly numerous times. And you were never able to see anything, correct?
Correct.
So apparently, this business is in no way affecting the appearance of the house. Is that correct?
From the outside, you don't see any evidence of what might be going on inside.
Is there any noise that you've ever detected on your multiple inspections of the property?
I'm usually in the right-of-way, usually over on Gregg Court or even on Tolls Creek, so I cannot answer to any noise without being actually on the property.
Any odors emanating from the garage that you're aware of?
Same answer, without actually being on the parcel, it would be kind of difficult to make that determination.
Other than being able to go to social media and see the posts that he made, is there any evidence whatsoever that there is anything taking place on that property?
Well, as I said, with that one vehicle that I did identify with my own eyes.
I'm agreeing that it's taking place.
Right.
But if you're driving by routinely looking at the place, you wouldn't know. You can't see anything about it.
Well, if you actually look at the parcel off of Tolls Creek, you wouldn't be able to see anything anyway, because the driveway goes from Tolls Creek all the way back. The garage is behind the house. You can't see anything from Tolls Creek, but you can from Gregg Court.
But for somebody who was specifically investigating to determine if what was going on there somehow impacted the character of the residential neighborhood, you couldn't see anything until you went on social media and found the photographs, right?
I don't know what type of impact would be
To even determine if it was taking place, you had to go on the internet and find pictures that were taken inside the garage, right?
True.
So from the exterior, to anybody living around there, you can't even see it's going on.
I can't speak to whom lives nearby, but,
How many
from
times-
the outside of when I was driving, I could not see anything, no.
And how many times did you go by specifically investigating to see if this business was taking place? Over 20?
All conclusive from the first notice of violation. I'm calculating. $20 is probably a good number, yes.
So 20 times going out there looking to see if you could even tell if a business was being conducted. One time you saw a car go in the garage. Is that right?
Yes, that's
These were
correct.
random times, random days, with you trying to see if there was a business going on there.
Correct, Monday through Friday, 8 to 4 approximately.
No other questions?
I have no questions. No further questions.
Does the board have any questions?
You guys have any questions? Sir?
I did one.
Oh, go ahead.
Ms. Rogers, in this second email, it doesn't have a date on it, so I don't know what date it is. Where you were listing noise levels,
Yes, sir.
it says, I have done several drive-bys, but haven't seen any evidence of commercial activity.
That is correct. That's, goes along again with what Mr. Schilling was saying, that whenever I do drive by, just to identify and look at the property, majority of the time, I did not see any evidence of anything going on at that time.
Okay.
Okay.
Yeah, concerning the vehicle that you did see go in the garage and leave, are you able to testify that you know that to be transactional in nature? Or that could have been a friend helping a friend, or how do you know that?
There's no way for me to make that determination. It was just strange vehicle, Virginia plates, looked out of place, went in, drove into the garage after it was open, came back out, newly tinted.
Okay. And then, I'm not a lawyer, so excuse my ignorance here. What statute or authority in the state of North Carolina or Currituck County allows you to take photographs and sit out front of a person's property in the county to collect the evidence?
Anything that's obtained from a right-of-way, and that's where all these pictures come from.
Very good, okay. The first notice you said was in compliance,
Yes,
and then is it the county's, I guess, rules to readdress an issue if it keeps coming up, or I guess, what's the timeline there?
if we receive another complaint, we again follow through our steps. We go in as a complaint, we do our investigation. If we make that determination that there is a violation, then the notice of violation is sent out. We look at all the external factors to include previous violations on the property, or issues with permits and those type of things that are in our system.
Okay, and you also testified you went up his driveway? Did you have permission to do that?
In the role of my job, I can go up a driveway, just as in any other delivery driver or any
Okay.
sort.
Okay. Well, I can't ask your opinion, that's all I have. Thank you.
Ms. Rogers, am I correct in saying that when you stated earlier that the first violation was said to be compliant, were you meaning that based on the little evidence that you all had, that, and you not knowing that they were in violation of the home occupation section, that was the reason that it was said to be compliant and it was kind of dropped? Or what's the best way to describe how that came to be?
Well, let me go back to. So what happens is we receive a complaint. That complaint came in. I went out, could not see anything at that time. So it remained a complaint. It went to a violation once I noted through my social media, looking at that those vehicles were being done on that parcel. It wasn't until after Mr. Currituck came in, spoke to our planners, they researched the UDO to make the determination based on the violation, which I had issued as a home occupation violation. Whenever they made that determination that he was in fact violating that home occupation, that's when I contacted Mr. Currituck with that email and told him that he was not allowed to do that on the property. He responded, and that led me to, and I hate this word, to assume that he understood that he could no longer operate on that property. That is when I marked it complied.
Understood. So what you're saying is once you had sent an email to him letting him know that this was not a compliant act that was happening at the property, you marked it as being complied with because you thought he was going to stop doing the activity.
Well, and during that process, from the time when he came in on June 2nd to the time I sent that email on June 24th, I continued to monitor the property to see if there was any evidence of the operation of the tinting business still going on the property, which I did not see.
And I'm correct in saying that it is a fact that if the doors are closed, you can't see what's going on the inside, even though they have the 3 little bitty windows in the door.
That is correct.
One more question. So when you applied automotive repair in the like in your investigation, who determined in the like window tinting fell into that categorization?
Well, as Ms. Turner had mentioned, that was seen as a service. That service is being done on an automobile, I should say.
Who in the county made that determination?
Well, when the 3 planners who got together, how's the word? They basically looked at the UDO to make a determination.
The reason why I bring this up is because the UDO has specific language on the ambiguity inside the UDO, and that rests. I won't continue. We'll continue the trial here, but that's something to keep in the back of your head, in my opinion. That's all.
Okay.
Any other questions from the board?
I do. If he's doing automotive and in an enclosed area, there's always a risk of fire. Has the place been inspected by the fire marshal to make sure that there's compliance with fire extinguishers for the different explosions that can happen or what have you, with any kind of chemicals that he's using? Did we get that far yet?
I don't know what type of regulations the fire marshal is required in especially with a business that's located in or near a residence.
Okay.
I'm not aware that would be something that,
Do you know if this area that he's using is compliant with the Americans with Disability Act? Is there, and I don't know if it's needed, but I know that every business has to have a handicap spot, handicap parking spot. They have to have a handicap bathroom. Is any of that in there? And that, there's no getting around that.
that I do not know. Obviously, that is part of the process when our planners are looking at building plans, what our chief building inspector would look at as well whenever those come into, to be permitted through our, county.
Okay.
But again, that's,
So that hasn't been addressed yet at all. Okay.
Any other questions from the board? Do you have any other witnesses?
No, Your Honor, those are the county's only witnesses.
Okay. Or any other rebuttal?
Before I put on any other testimony, I would just make a motion at this time to go ahead and grant
Well,
the appeal.
Well, hang on a second. Let's excuse Ms. Rogers
Yes.
before you guys start going back and forth. Thank you.
thank you.
Again, if we look at whether or not this is a home occupation and just understand the structure, there are general standards, but specifically they've carved out, these are an exception. In a residential area, you can have a home occupation. And it says, a home occupation shall be permitted. And when it comes to legislative interpretation, the word shall has a lot of meaning. It doesn't mean you can, doesn't mean you may, it shall. It shall be permitted as accessory to any principal dwelling unit, provided that the accessory use will not change the character of the residential neighborhood in terms of appearance, noise, odors, traffic, or other impacts. Now, the county wants to point to this one sentence, which is, home occupation does not include such businesses as automotive repair and the like. When we use phrases like such businesses as or and the like, we're trying to give an example. Things like this are not included. And automotive repair, when people think of automotive repair, they don't think of somebody, and for purposes of explanation, window tint is a sticker that you apply with soapy water to a window. It is silent. There is no noise. As the evidence has been, when the county goes by multiple times to try and even see if this business is being conducted, you can't even see it's going on. There's no evidence from the testimony of any violation of the standards that you're supposed to be looking at. So it doesn't really meet, again, it's sort of a circular argument. If it was an automotive repair shop, there would be noise. There would be odors. There would be cars parked out front. That's why we use the word such as. Things like this, things that we commonly understand to be noisy and dirty and uncharacteristic of a neighborhood. But when we look at the specific standards that are listed and when I asked the county to describe, there's no evidence that the portion of the area that is being used for the vehicles exceeds 1,000 square feet. And if you look at the pictures, you can see that the cars don't take up the entire, the pictures that were introduced by the county show that the vehicles don't take up the entire third bay. You can't just take the whole building and say, well, a third of that is for the business. He's saying that one of the garage, you pull the car in the garage. 1,000 square feet would be a space, it is simple math, it would be a space 20 feet wide and 50 feet long. He's not using that much space to pull one car in the garage.
If I may, I hate to interrupt, but none of this has been introduced into evidence. I don't know if Mr. Schilling is testifying at this point.
Actually, they did. The photographs they introduced show you the inside of the bay and show you the one car parked in there.
Well, you just said that he was moving one car in at a time, or you said something that he said. We haven't heard from your client yet.
I was just going based on the multiple pictures they introduced. of what's going on inside the shop. So you can extrapolate from looking at the picture that he's not using a third of that entire garage.
What it sounds like to me is you're trying to make closing arguments before you're actually closing. So maybe we
Okay.
go ahead with,
It's the county's position
Yes,
that he continue with his evidence. I think that would be very helpful for the board.
It just
To make a
seems so obvious
determination.
based on the testimony. It seems
I completely
unnecessary.
disagree. I completely disagree.
okay. Is staff finished with their presentation?
Yes, Mr. Chair, that is the county's evidence.
All right, so in regards to, I believe Mr. Schilling was making a motion to dismiss the notice of violation. If I can just kind of, you said grant the appeal, but that was the equivalent of his motion. And so the rules of, I guess, procedure as we kind of operate here, and then we, due process, and we kind of have this like blended process here and when you guys are sitting as the quasi judicial board. And so our rules of procedure have kind of an outline of how you are going to go through each hearing. And Mr. Schilling, I guess, is asking that you cut that short and go ahead and summarily grant his client's request. So for the record, I do think you need to vote on his motion. And so his motion is to, without him having to proceed any further, and in court, the standard is, and the evidence viewed most favorably for the non-moving party, in this case, the county, do you feel like you can grant his motion? And so,
And if I can just conclude my argument on that before you make a ruling, that'd be great.
okay. And so what he's asking for you to do is cut short the hearing at this point based on what you've heard. And he feels like that his argument is that you can make that decision right now. Now, the board's option here is to grant his motion, deny his motion. If you grant his motion, the hearing's over. If you deny his motion, the hearing proceeds to the next step, which would then be the appellant's case. Okay? So, and I think he did want to briefly wrap up his argument.
So am
for
I
his
correct
motion.
in saying that if we were to agree with his motion, we are not having the applicant admit guilt? Is that correct? Or is that just stopping the hearing and?
So his motion really would be, it's really that based on the evidence that you've heard to this point, that you have no choice but to grant it. It doesn't matter what he's going to present. And so that's his position. County, maybe after he argues, will want to be heard, but let's go ahead and let him finish briefly. I think he's almost done.
I am.
All right.
And then we'll hear from the county, and that's kind of where you guys are in terms of making a decision on that motion.
Okay.
So what I was getting at is that this creates a presumption. When it puts in the statute that it shall be permitted, provided that these things are done, it shifts the burden. The burden's on the county to show that it does alter the character or change the nature of the residential neighborhood in terms of appearance, noise, odor, traffic, or other impacts. And if they don't show those things, then the home occupation shall be permitted. So the burden's really not on him to show that it doesn't. The burden is on them to show that it does. And when we went through the specific standards that are listed, the county relied on number 1, which they said it was greater than 1,000 square feet, but they have no evidence of that. They relied on number 6, which was all vehicles used in connection with the business, but then they conceded that they don't have any evidence of that. Then they relied on number 7, which was traffic, but then they conceded that the traffic impact was low. And then they relied on number 11, which they said was unclear. So none of the standards that they're relying on have they presented any evidence to support. What they've simply put on is, hey, we've decided that window tinting is automotive repair, and there's window tinting going on. But the problem with that is that the way the statute is set up, home occupation does not include such businesses as automotive repair and the like, is designed to give you an example of the kinds of things that wouldn't be permitted as a home occupation, because they change the character of the residential neighborhood in terms of appearance, noise, odors, traffic, and other impacts. But if you can determine right now that this business, that the county went out multiple times trying to see if it was going on and they couldn't even see evidence of that, if you would agree based on that alone, that the presence of 25210 has not changed the character of the residential neighborhood, you don't need to go any further. You can say, well, obviously it doesn't have any impact. It has not, it doesn't create, the appearance is the same. There's no noise, there's no evidence of any noise. There's no evidence of any odors. There's no evidence of excessive traffic, and there's frankly no evidence of any impact that this business makes on the neighborhood at all. And if you agree with that, then we can stop.
If I may, the UDO lays out the procedure for these public hearings, and absent a text amendment that is approved by the Board of Commissioners, we have to follow that procedure.
I don't think I understood. I'm sorry.
The Unified Development Ordinance, it lists out the procedures for a public hearing, which is what this is. And so, and which includes applicant or the testimony of your client. It includes different things, and we haven't got there yet. So the only way to grant this motion would be a text amendment by the Board of Commissioners, which is obviously impossible at this point. So the county would argue that this board is required to follow the typical public hearing procedures laid out by the Unified Development Ordinance.
So, well, let me ask the county this. Do you have, other than the procedural objection, do you have argument in response to his motion at this juncture?
I believe that the county believes that the board I would like to actually question the appellant. There has been evidence introduced by county staff that I think is enough to move forward. I definitely do not think, I think the county has more than met its burden, that the window tinting use is similar to automotive repair and the like, which is completely prohibited by home occupation. Even if you disagree with that, I believe there has been some evidence, testimony discussing the size of the facility, which exceeds the home occupation standards. So I think the county has more than met its burden to move forward and not dismiss the notice of violation at this point. So the county argues that to deny appellant's motion.
And then I get to respond typically. And so my response would simply be that if you agree that the presumption is that it shall be permitted, like the statute says, unless they prove these things, and they haven't put on evidence. So for instance, like, she doesn't know, does anyone here know what window tinting involves? I mean, has there been any evidence of that? Of like what would be required? If there are any, there's been no evidence of that. Is there any evidence of any noise? Is there any actual evidence of how much space in the garage is used? Is there any evidence of how many cars go there, or any evidence of any of the things that you're supposed to, that the county is supposed to prove? And they're not supposed to rely on him to prove it. They're supposed to put it on. And if they haven't, then we should be done.
So you'd like me to get their opinion about, or have a vote on it?
Yeah, so you have to have a vote on the motion, on this motion. You need to, again, this is a motion.
Only a majority.
I'm sorry?
Only a majority.
Correct, this isn't a variance. Any decision that you make tonight, be it on a motion or in general, is a simple majority vote.
Now, when it comes to, if, let's say, the board voted yes to approve the dismissal of this NOV,
So the board has to, according to, let me pull up my notes here. My computer wants to be slow. Give me just a minute. So in regards to appeals review standards in the ordinance, the Board of Adjustments limited to the following. You have to, A, find that the decision maker did not make an error or correctly applied the standards of the ordinance in making the decision or interpretation, right? Then you have B, the decision maker made an error in determining whether a standard was met. And I'm not reading the entire paragraph, just so everybody knows. I'm kind of jumping through your options, and I can read the entire thing if you want to hear it. C, the decision maker made the decision based on a standard not contained in the ordinance or other appropriate county ordinance regulations or state law. Or that a standard more strict or broad than the standard established in this ordinance was applied. Okay? Or the last option is the decision maker made an error in applying a standard or measuring the standard. So the board of, you have to make your options tonight are to basically affirm staff. You have all the authority staff has when you are reviewing a notice violation. You can affirm staff. You can say that staff got it partially right and partially wrong. You can say staff got it right, but I think that's for these reasons, it matches this definition, and I'm using just because we're talking about this. Or you can say, I think staff got it wrong, and this is why staff got it wrong. And so at this juncture, for this motion, the only thing you are considering is his motion, which is completely staff just got it wrong. That is the only option that you are considering at this point. So you have, and if you say, no, we don't agree with that at this juncture, we need to keep going, and you need to put evidence on, then we keep going. Or you say, yes, at this point we agree completely, staff got it wrong. That's where you are right now. And you do need a vote.
all right.
A motion and a vote
Well,
to either grant his motion or deny his motion.
well, before I vote on it, I mean, Mr. Schilling has pointed out about the effect on the neighborhood. And we saw a bunch of witnesses that have been sworn in. Is the county going to are we going to hear testimony from those witnesses about the neighborhood?
I don't know who those they're not county witnesses.
They're here for Mr. Kralik.
Okay. So county is resting.
Correct.
Okay.
That's correct.
Okay. I'll go ahead and make the motion. I'd like to make a motion to how will we put that? Affirm his motion.
So are you wanting to, do you agree with Mr. Schilling?
I do not.
Okay, so you want the hearing to keep going?
Mm-hmm.
Okay, then that your motion, if you don't agree, then you can say your motion would be to deny his motion
Okay. And continue
at
on.
this time and continue on.
I'd like to make a motion to deny Mr. Schilling's motion to dismiss the NOV and that we continue on with the presentation of evidence.
I'll second that motion.
Okay, is there any discussion?
What did you say? I'm sorry?
Okay, we'll go ahead and vote then.
He said, is there any
Is
discussion?
there any discussion? Okay, if you
Because
wanted to talk about anything.
I'm on the
before we-
same way, but, yep.
All right, in that case, all in favor of the motion to continue on with evidence presentation, say aye.
Aye.
Aye. All those opposed, say nay.
Nay.
Okay, we have 4 ayes and 1 nay.
Did you get that, Sheree? Okay.
All right, in that case, we'll
we're going to
Continue on.
continue on, and it'll go to Mr. Schilling, and he did, I'm sorry?
Justin, sorry.
Was there a question?
No,
I
go ahead.
apologize.
I just was clarifying, sorry.
Okay. And Mr. Schilling deferred, kind of, some brief opening remarks. You don't have any. Okay, so, the case is with you.
And what I'm going to do, I don't even know all the names of all these people, so I'm just going to ask them to come up once at a time. Apparently, they have something they want to say to you, so just for the sake of
Yeah.
letting them go, some of them have small children and so forth, would the board have any objection to me just calling them up and giving them an opportunity to address the board?
You took the time to come out.
As
You're
long
talking.
as, as long as they did sign up and were sworn and Cherie knows.
Yeah.
And,
Sheree?
You want to recess? Okay. How long, Rick? 5 minutes? Okay,
A brief recess to use the restroom.
okay. Let's do a 10-minute recess just for a moment. So folks, if y'all need to use the restroom, we have a couple up here on this floor. We're going to recess for
These folks
10 minutes. Okay.
are we?
Yeah, she's ready. Yeah, she's ready.
If she's running around
All
back
right.
there, something.
We're going to resume the meeting. It's now 7:31. And the county has rested, correct?
Yes, they've rested, and Mr. Schilling made a motion. You denied his motion, and so now the case is with him, and I believe he's going to start calling witnesses.
I am indeed. The first witness I'm going to call is Caitlin Stitz, since she's back.
And do you have all these
No, I can just go
individuals
right
sworn? Cherie?
Over here.
Okay. Mr. Schilling, as your call, if somebody came in late and didn't get sworn, can you just let us know so we can get them on if there's not?
I'll
She
ask him
was,
as
but,
yes, he's.
okay.
Ms. Stitz, you've been sworn?
Yes,
Okay, and you're Caitlin Stitz?
that's me.
And you live at 2404 Tills Creek Road?
Correct.
All right, and there's some things you wanted to tell us about.
Yes. As he said, my name's Caitlin Stitz. I live at 2404 Tolls Creek Road. My family and I have been part of this community for 8 years. Excuse me, I just ran to take care of my children, so
Hey,
We're-
take a deep breath. It's cool.
we're raising our 3 children here. We care deeply about this place and the people who live around us. Last year, Gavin bought his home 2 doors down from us. From the moment he moved in, he's been nothing but respectful, polite, and incredibly quiet. He's the kind of neighbor you barely notice because he never causes a single problem. He waves, minds his business, and treats people around him with kindness. So when I heard that someone had filed this complaint about him, I was honestly taken aback. In all this time he's lived near us, I have never heard him once, his business, or any of his guests, day or night, not once. He does not disturb anyone's peace. He does not interfere with anybody's life. If anything, he blends into the neighborhood so seamlessly that you forget he's running a business at all. And that's what makes this situation so disheartening. Gavin's a good kid. He is a young man trying to build something for himself the right way, through hard work, dedication, and honesty. He isn't out causing trouble. He isn't disrespecting anyone. And he isn't taking from his community. He is contributing to it. We hear so many stories these days about young people making bad choices, but Gavin is the opposite of that. He bought a home. He started a business. He shows up every day and works hard. He treats his neighbors well, and he's doing everything we say we want young people to do. And instead of being supported, he's being challenged over something that has never bothered any of us in the neighborhood. It feels unfair to put obstacles in front of someone who is generally trying to make a positive life for himself. His business is used by so many people in this community, local residents, local businesses, people who rely on him. He is providing a service, supporting himself, and doing it without disturbing any of us in the neighborhood. Gavin is not a problem. He is not a nuisance. He is not a disruption. He is a hardworking, respectful young man who deserves the chance to keep building his future. And as his neighbor, as someone who sees him day in and day out, I can say with complete honesty that he's been nothing but an asset to our community. Thank you for your time.
Did you have any questions for your witness?
I don't think I could possibly have a question. So, no.
All right, hold on just 1 second. You're going to have to make the rounds, okay? Ms. Morgan, do you have any questions?
No questions.
Okay. Ford, do you have any questions?
No.
Thank you.
Thank you.
Next, I'd like to call Daryl Spruill.
There you go over here.
And again,
Come
Daryl,
on,
you-
come on up here.
Center of attention.
That's all right. You're on the end, so you're not in the middle there. You're good.
I'm Daryl Sproul, and I live at 114 Dozier Road. My wife and my sons have lived there for 32 years. We are aware of our surroundings, of our neighborhood, and what's going on. I have been a mechanic for 40 years. I would just like to say that automotive repair, if you're not aware, is to make a vehicle road-ready and safe per state inspection to be on our highways. Window tint has nothing to do with making it auto repair. It's brakes, engines, lights, transmissions, tires. That's automotive repair. And that's what makes it state-ready for the state of North Carolina or Virginia in an inspection to travel a highway safely, not to hurt anybody else. As far as Gavin is concerned, I haven't heard anything out of him. Polite young man, just like Caitlin was saying. Very nice. I know some of his friends. I coached him in rec baseball. Quiet. Don't see a lot of cars. I'm aware of my surroundings in my neighborhood because I have had two widowers on either side of me. One has moved away now. We make sure we keep an eye on our neighbors. I can remember when Craig Court was farmland. River's Edge was farmland. And I went to school with the farmers. That's how I know about my neighborhood and who they are. He's very polite, very respectful, very quiet. There's not a lot of cars coming in and out, not a lot of cars going. We've had other people that have lived in the neighborhood and there that have been a whole lot louder and a whole lot more noticeable than he's been with his job, with what he's trying to do. And again, like she said, polite young man trying to start a life. We should not whatsoever try to stop him from doing that. I don't want it from my boys. I definitely don't want it for him, and I'm sure his parents don't either. He's quiet, and he's doing his job quietly, not disturbing the neighborhood. And trust me, like we said, window tint, soap and water, and a squeegee. There's no chemicals, there's no tools, and like I said, I'm a mechanic. Impacts and sledgehammers make an awful lot of noise. All I got to say.
Do you have any
Just one
questions
follow-up.
for your
So
witness?
You've been around automotive repair shops for how long?
I've been around automotive and heavy equipment repair shops for at least 40 years.
And would you say that what Gavin and 25210 is doing on that property is akin to a automotive repair or the like?
Absolutely not.
Nothing further.
Any other questions?
No further.
And staff,
No questions.
county? All right, thank you, sir.
Thank you.
And last, I'd like to call, well, not last,
Apologize,
Mr. Craig,
Ron.
but
Oh, did
as
the
far
board
as,
have any questions for him?
Did you have a question, Rob?
I'm sorry.
Mr. Sproul,
Sorry.
Sorry.
you can answer from there. Where is your property on Dozer Road compared to Mr. Currituck?
Got to at least get to a microphone. I'm sorry.
Side, right beside him.
Conjoining.
Yes, sir.
Okay, that's all I need to know.
All right.
Anybody else before we let him go?
No, you're clear now.
Procedure question. Can we use that in our determination, or does he have to be qualified as an expert witness?
What part?
Everything he said about what is
So-
defining a automotive repair shop and what isn't.
Sure.
Yeah.
So the board is, in regards to the weight of you give the evidence that's presented to you, is in from a witness is in your discretion. Is what weighs more heavily in one hand versus another. The board is, I guess in terms of a witness structure. He was not qualified as an expert witness, but that was not the intent.
Okay.
You know, you have to,
I'd be happy to do so.
you just have to,
Be happy to do so. I'll lay a foundation.
well, I'm not, he's your witness, I'm not going to, but in terms of like, you can't take that as expert testimony because he's not been tendered as an expert.
Right.
But is it competent testimony from his perspective and his point of view? Then in that framework, yes, you can, he's a sworn witness called by the appellant,
Okay, thank you.
if that answers your question. Okay.
I'm not going to ask any follow-up. We're good.
Okay. Thank you.
Thank you.
Next, I would call Linda Mackley. Again, Ms. Mackley, you've been sworn,
name.
correct? You've been sworn already?
Hello.
And Ms. Mackley, you live at 101 Gregg Court, is that right?
Yes,
And just to follow up on what Mr. Kane said, where is that in relation to the property we're talking about?
my backyard butts up to his backyard. I have a bird's eye view to the 3 bays. I've only seen one bay go up. A car goes in, it comes out, the windows are darkened. I've seen the others go up, I've never seen a vehicle go in the other 2 bays. We don't hear any noise. We've never been kept awake. I've never heard any foul language. They're quiet. I feel like if anybody had a reason to gripe, it would be us. But I have no problem with what he does over there. He's very well-mannered, and basically everything they said about him as far as his character, he's a great kid, and he's a hard worker.
Okay.
So I have no problems whatsoever.
Do you feel that the presence of 252 Tint in that location changes the character of your residential neighborhood?
I do not.
Nothing further.
No questions.
All right, thank you, ma'am.
Board, do you have any questions?
No, we don't.
Huh? No.
Oh, I'm sorry.
Next, I'd like to call Gavin Kralik. And before I do that, may I approach, just to return this?
Yes, please, thank you.
So I don't forget, get slid in all the rest of my papers.
Yeah, we don't be fussing. Thanks.
All right, you're Gavin Kralik,
Yep,
and you live at 2388 Tulsa Creek Road, is that right?
that's correct.
And
Yep,
that's also where you locate your business,
correct.
25210 Incorporated, right?
LLC. Yep.
LLC,
You got it.
sorry, big difference. All right. And when did you start your business?
A little over 6 years ago.
How old are you, Gavin?
Right now,
Yeah,
I'm 21.
so you started it when you were,
15 before I had a license.
so you started this when you were in,
It was sophomore year, I believe. Yep.
Sophomore year of high school.
Correct.
and have been running, and now you have a business, do you have any employees?
No, I do not.
But you've been able to purchase your own home
Correct.
from this business that you run.
Correct.
Way to go. A lot
Thank you.
of kids your age can't do that. Tell me about installing window tint. What do you do?
You wet the window, you cut the tint out. It's a flat piece of polyester, just a big sheet of it. What is it? You lay it on the window, you cut it out, and then you clean the inside of the window, spray more water, peel the film back, lay it on the window itself, and then squeegee it out, any water, to the inside of the window.
What chemicals are used?
Just soap and water. I use Palmolive dish soap and just water, just distilled water.
From when I was a kid, you're soaking in it. That's the stuff we're talking about?
Correct, yeah.
All right. Anything more corrosive than Palmolive dish soap?
No, not at all.
So it smells like clean dishes in your shop.
It does, it does.
In addition to, you do cars.
Correct.
Do you do anything else?
Yep, we do buildings, houses, storefronts, heavy equipment. That's a lot of what I do.
Commercial buildings?
Correct.
Ever done a law office before?
I've done yours.
Oh, that's right. Okay. Residential homes?
I've done yours as well.
That's what I did. All right. But not just mine, you do other people.
Correct. Multiple others as well.
All right. About what percentage of the business is outside of that location?
I'd say 50-50. Usually to start my day, I'll go out, tent some heavy equipment, a house. It really just depends on the day. Then I'll come back and do maybe 1 or 2 vehicles at my own shop, at my residence.
And you make it sound real easy, just cut it out and spray some water and lay it on. There's a skill and a talent.
Correct. There is.
And you've become someone who's in demand for that kind of work.
Correct. Yes, sir. I stay busy.
Built a successful business.
Yes, sir.
That you started when you were 15 years old. And some of the work that you do work for the county.
Correct.
Who tints the cars for the sheriff's department?
I do.
And who tints the cars for the fire departments?
I do.
And you do that as a courtesy for the county, is that
Correct. I do not charge them at all.
And do they sometimes bring sheriff's vehicles over to your shop?
They have before.
And
Yes, sir.
sometimes the fire department brings vehicles over to your shop?
Correct.
When you first started this, obviously you started 6 years ago. Where were you living when you started it?
At my parents' house.
And you ran the business out of your shop, out of their garage?
Correct. For about, I'd say, 1 year and 8 months.
And where was that house located?
The south end of Tulls Creek in River's Edge.
In River's Edge. When we look at exhibit number 1, that shows what a single-family residential mainland use looks like, do you recognize this map of this neighborhood in the upper right-hand corner?
Yes, I do.
That's River's Edge, isn't it?
Yes, it is.
So the very example of what is a single-family residential mainland that the county uses as an example of that is where you located your shop for how many years?
About 1 year and 8 months, I'd say.
And then after that, you moved it to another location in Currituck County?
Correct, off of South Mills Road, still in Moyock, between that and Camellia, or I believe it's Camellia Drive. And I was there for just under 3 years.
So for 5 years before you moved into the location on Tulls Creek Road, you did the exact same business in 2 other residential neighborhoods in Currituck County without any complaints, without any concerns, without any code enforcement violations from the county.
That is correct.
As far as the size of the shop that you're in now, so it's a 3-bay garage?
It is.
And you told the county that you use one of the bays.
Yes, I didn't say the entire bay. I just said I do use one bay for work.
All right. When you use that bay, what do you do with it?
I pull the vehicle in. I have my toolbox next to it, about, I'd say, 5 feet from the vehicle. And that's the only space I utilize. I really just need space to park a vehicle that's blocked from the wind and everything like that.
I mean, you could theoretically, I suppose, do it in your driveway, and then you wouldn't be using any of the garage.
That is correct.
But you do it inside the garage so the neighbors can't see?
Correct, yeah. Keep it not hidden from plain sight, but, so no one has to see it. And it is just a nicer working environment.
And I'm assuming when you're putting on window tint, dust and things like that are...
Not good, typically. Yes, sir.
You want to do a good job, so you keep it in an enclosed space.
Correct.
But that bay is considerably larger than the space that you need to tint a car?
It is, yes, sir.
Do you ever have multiple customers come, like cars waiting lined up to go?
It's not common. It's very far and few between.
You do it by appointment?
Correct. I'm not open to the public.
When the customers come by, they wait for the car to be finished?
Typically, yes, sir. I'd say it's about 90% of people wait for it to be done at my shop.
Because it takes about how long to tint a car?
Full car is about an hour, hour and a half.
So is there a bunch of cars parked in your front yard or parts like that?
Not at all.
All right. Is there any equipment that is used other than the squeegee and the soap?
The spray bottle to spray it, and I have a tool belt as well. That's about it.
But nothing motorized, no air compressors, nothing that makes any noise?
Not at all.
So there's no noise, there's no odor?
Not at all.
Okay. As far as vehicles used in connection with the business, you have your own truck that you drive out to other locations?
Correct.
But other than that, are there any vehicles used in connection with the business?
None others.
All right. So there's no traffic congestion caused by your business?
Correct.
There's no parking congestion caused by your business?
Correct.
There's no noise caused by your business?
Correct.
There's no vibration caused by your business?
Correct.
No odors, glare, fumes, or electrical or communications interference that are caused by your business?
None at all.
It just takes place quietly inside your garage where none of your neighbors can see it?
That's correct.
And if you had to I mean, so it's the size of a parking space? Is
Correct.
the amount that you use in the garage?
Maybe slightly bigger.
Cars are, what, 6, 7 feet wide?
At the widest, and I'd say about, I don't know, 10, maybe 20 foot long.
But 6 or 7 feet wide, 10, 20 foot long?
Correct.
So well under 1,000 square feet that you're using.
That's correct.
I don't have any other questions.
All right, just a couple questions. So it's your testimony tonight that you never use more than the 1,000 square feet?
That is correct. Yes, ma'am.
Okay. Even when the fire truck comes in that you testify to tenting, you don't use more than 1,000 square feet for
No,
that?
ma'am. So as far as fire engines go, I do that that was for Southern Currituck. I did that at the fire station.
Okay.
The vehicles I've done for Crawford are usually their F-250s they have, which are just the size of a standard pickup.
About how many vehicles do you typically do at the house, at the residence?
In what amount of time period, you say?
In a week?
In a week, I'd say anywhere from 10 to 12 at most. That's during the busy season, which is summertime.
Okay, so 10 to 12 vehicles are coming to and from your house to get tinted?
A week, yes, ma'am.
Okay.
I'd say, depending on the time of year, but on average, yes, ma'am.
And I know you've been sitting here listening to testimony, and it's staff's position that this is automobile repair and the like. And obviously, you disagree. What else would window tinting be?
Does it have to be defined, is my question?
I'm going to object. That's asking him to conclude what the ordinance says. That's really not something for a witness to testify to.
Do you want to rephrase your question?
Sure. So it's your position that window tinting is not automotive repair and the like?
Per the county's
That's
definition,
just
yes.
asking the same question a different way. That's still going to the ultimate question.
Well, I think she can ask him if he agrees with staff's interpretation. And I think that was the question that she was asking, was he disagrees that it's not automotive repair and the like. Is that
Yes.
The question, that's what I heard. And he said no.
Okay.
And he said, no, he doesn't agree. And then I think we cut him off. But
Do you know how big the garage space is?
Total?
Yes.
It's 50 by 70, which is 3,750 square feet.
What do you do with the other part of the-
In the wintertime, I'll store my boat in the far bay. I have a bar in the middle. I have cornhole boards set up in the middle bay as well. That's about it. It kind of flip-flops around. I have my lawnmower parked in there. Changes a lot, but I just store my personal stuff in it.
And do you know how big the residence is on the property?
I believe it was said earlier is 1221
Okay.
square feet. Yes, ma'am.
Okay, I have nothing further. Thank you.
Any follow-up with you?
No, sir.
Any questions for the board?
I do. I just have one. Congratulations on what you've accomplished, and that's to be commended, really. When you open up a business and when you start a business, you have to file paperwork with the state and get your right name correct. The lawyers help you through all that. You also have to apply for a permit to be able to do that business wherever you are. The other two places where you were working, not mom and dad's garage, but the other two places, did you ever apply to the county for a permit to be able to work there?
Are you saying like a business license? Mm-hmm. Currituck County doesn't require one. There's no such thing in Currituck County.
If you're going to do a business of any kind, you have to apply for a permit through Currituck County.
I was not aware of that,
Okay.
to be honest with you. I am a licensed, or I am an LLC, an official business, but I did not know about that.
All that end is all in order, but they have to allow you to do your business in the county,
Okay,
because they don't allow certain types of businesses.
understood,
They regulate it that way. Okay.
understood.
Any other questions? Go ahead.
Hey, so with your interaction with the county, how were you notified?
For the first violation, I was notified via an email, which was then followed with a letter in the mail. The second, or I say altercations, it wasn't near that. What is it? The second time I spoke with them was via an email, and that was just a question/concern in their words. Then the third time I was notified also with an email, which was also followed by a letter sent to my mailbox.
Okay, and what was your response to that?
The first time, like Ms. Rogers said it all as well, I came in, spoke to all the planning board members. I believe that's who they were. And then about a month later, they came back and found me in compliance via email. What is it? The second time, what is it? I just emailed her back. You guys saw that earlier as well. And then the third time, what was your question again? I apologize.
At any point, did they tell you to stop doing business as is? And did you affirm that in any way with any response?
They never told me to stop. They just said it wasn't allowed because it was automotive repair. That's what was told to me.
Okay.
I have one question for you, sir. Did I hear you clearly when you said that the building was 30 by 50?
75 by 50.
75, okay,
Yes, sir.
thank you. That's all I had.
And I have
Thank
one
you.
question. That when you obtained that property, was the building already there?
Yes, sir, it was. I believe it was built in 91. It's on the tax record.
Yeah.
Any other questions by the board?
No, I'm good.
Nothing further here?
Okay, and the county, nothing else?
No, thank you.
All right, thank you. You're dismissed. Thank you. Did you have any other witnesses you wanted to bring forth?
No, sir, that's it.
Okay, that will end the public hearing.
Well, I think that just for your procedure, you do have to ask about the public comment. I don't know that.
All the persons that were on the public comment
Oh, okay, perfect.
were brought up as a witness unless there's someone else who wanted to speak. Okay, there are no others there.
Well, we have to check.
Okay, that will officially end the public comment period. Let's see. Well, they were testifying and they had no questions also, so that was covered. Okay, now how would you like us to proceed on any
So-
other areas other than
So just in
voting?
regards to the conduct of the meeting, after public comment, the board would give the applicant and the county an opportunity to respond, but since there is no public comment, that's not applicable here.
Right.
So at this juncture, usually, the county and appellant have the opportunity to give brief closing statements.
I'll just stand on what I said.
And then after their closing arguments to you, then you would proceed to deliberation
Right.
and voting. So at this point, we'd turn to
There you go.
Yes, the county would like to make just a brief closing statement.
Yeah.
So what this case really hinges on is whether this is allowed as a home occupation. Because a business like this is not allowed as a principal use, so we're looking at the accessory use standards, and that leads us to home occupation. The county doesn't argue that it probably doesn't meet a lot of those standards. It doesn't have to. We had, I think, 3 witnesses talk about no noise, no odor, no traffic. We don't dispute that. Our own witnesses testified to that they either didn't know or they didn't witness it themselves. However, within that home occupation, paragraph, it does state that it does not include automobile repair and the like. Now, how staff walked you through that, how they got to automobile repair and the like, because window tinting, which is, they stipulate that's exactly what he's doing. They don't argue that point. It's not listed in the UDO. So staff is required to then use those factors, which we presented material, substantial, competent evidence on all of those factors that were relevant. Ms. Turner walked you through every single one of those and determined that it was most similar to automobile repair and the like. Not just automobile repair, it's and the like. And when you look at that category of vehicle sales and services, which also Ms. Turner testified to, there's multiple categories of automobile repair and services, painting, all sorts of things that she testified to. And that is just the most similar use. That doesn't mean that it fits perfectly in that category. It's just county's job is to go through the ordinance and go through those factors, which is exactly what they did, and it came to that conclusion. And the shall language that Mr. Schilling harps on in that home occupation standard, shall permit, that doesn't negate that next part of the provision that says automobile repair and the like is not permitted. So you really have to look at everything together. The UDO is its own animal, and it's like you got to look at this section and then go over to this section, and that you have to look at like 100 different sections to come up with the answer. The county doesn't dispute that Mr. Kralik, he sounds like a wonderful citizen of the community. He's doing a really great job. That's fantastic. He had multiple character witnesses to testify to that. We don't argue that. Unfortunately, that's not relevant here. I know that sounds harsh, but it really is not. It's not relevant here. So it's the county's position that through Ms. Turner, with her interpretation of the UDO, and Ms. Rogers, with her thorough investigation, that the county presented to you material, substantial, competent evidence to affirm that notice of violation, that automobile repair and the like is similar to window tinting, and that is not allowed as a home occupation. So the county would ask that you affirm that notice of violation. And thank you for your time.
Ms. Shelley?
I'm a lawyer, I can't help myself. I gotta talk. The UDO is broad and covers a lot of things, but what's nice about what's presented tonight is it's literally just about this one paragraph. That's it. Because when there's a narrow standard, you just go straight to that narrow standard. The general standards don't matter. So the question is this a home occupation? And it says, it shall be permitted, provided that it doesn't change the character. And again, I mean, I do keep harping on it because that's the statute. And it says, shall be permitted. So you don't have an option here if you find that it does not change the character of the residential neighborhood in terms of appearance, noise, odors, traffic, or other impacts. Shall be permitted. Now, the part about automotive repair, it says home occupation does not include such businesses as. So it's designed to give you examples. It's like if I was saying chocolate candies include things such as M&Ms. And that doesn't mean that a peanut butter M&M, or a Reese's Pieces is necessarily falls into that category. It's not intended to be a laundry list that says these specific things, but even if it were, the evidence that you've heard tonight is that this isn't really an automotive repair business. The reason automotive repair businesses are excluded from home occupations is because when we think of an automotive repair business, we specifically think of something that is loud and noisy, and there's junk out in the yard, and it causes a lot of traffic, all the things that are noticeably absent from what is presented to you. The business that is presented to you is very different than an automotive repair business, specifically because it's virtually invisible. Even when the county's trying really hard to find it, they couldn't see it. It makes no noise. The neighbors will tell you there's no noise, there's no odors, there's no traffic. And literally the people who surround it every single day tell you it has no impact on them whatsoever. I don't think you could have any more compelling testimony than that. I would ask that you find that this is a home occupation that does not adversely affect the neighborhood, just like the neighbors say, and allow him to continue to operate there.
All right, I believe we have heard all of the evidence and closing arguments from the county and the appellant. And is there any discussion among the board?
And just as a reminder, because you guys haven't been here in so long, and maybe you're a little rusty, and we're all just kind of re-gearing up when you are deliberating. It's important because an order has to come out of this. Whatever way your decision is going, you need to talk about your reasoning for your decision and the reasoning for your vote. It's the only way that the folks who came out tonight, county and applicant, can know the basis of your decision. It's important for the court if there's an appeal that follows this. So make sure, in this kind of discussion, you can have some discussion. If someone wants to go ahead and make a motion, you can make a motion, but then you need to have discussion on that motion because ultimately we need to know what to put in the order. So that's really important. And then just kind of as a brief refresher, because you are sitting as a quasi-judicial board, you can only consider the evidence that was presented here tonight. So if it wasn't presented here tonight through a witness, you can't consider it. And then, of course, those things we covered earlier and what was admitted or not admitted, things of that nature. So that's just kind of my brief refresher for you. I read you the options that you have available to you when you are making this type of decision. So if you have questions procedurally, I can try to assist you with those. But otherwise, just make sure you have discussion so we know what to put in the order.
Any comments, Robin?
I did. So we need to make a determination on one of these standards that we're allowed to make judgment on. And unless I missed everything completely, the county has made it an interpretation of what automotive repair and such is. They've made a determination that window tinting is that. Now, I guess what we need to decide is whether that interpretation is correct. And I think it is not, and so I'm going to say we vote for D. The decision maker made an error in applying a standard or measuring a standard.
Do you have any comments, Mr. Balance?
Yes, just briefly. I would agree with staff that this would be a commercial use and should be done in a commercial setting. The same table was, I believe it also would fall part of vehicle sales and services category is also car washing and detailing, which is simply soap and water. It's not allowed. I'm again not discounting Gavin's success, but given the way that we would apply this to any other property, that would be how I would look at it.
Yeah, so the procedures that the county used to obtain their evidence is unclear to me. And the reason why I say that is because the UDO, now I could be wrong on this, UDO 2.4.16 is director interpretation. And nowhere in the evidence does it say that in the like was determined by the director, unless I'm wrong. That initiated the investigation to begin with, so they were collecting evidence, but the in the like part didn't come until all of this process started.
So procedurally, again, you weigh the evidence and the testimony of who presented it to you. The only reason I guess I want some clarification because I want to make sure I understand that what you're saying from that section, because I don't want you to make it misapply
Sure,
that
yeah,
section to
you're right.
your
Yeah.
view of the evidence. Your view of the evidence is what it is, and I'm not commenting on that. So I guess I want to better understand. Can you go through that again for me?
So the way I understand the procedure is the director, per the UDO, has the authority to interpret the ambiguity within the UDO and apply it to protect the citizens of Currituck County. My question is, where in the process was that interpretation applied to start this process? And when I asked the kind lady from the enforcement, who authorized this as in the like? Who authorized tinting as in the like? And her response was the planning board or her colleagues, not the director. And the UDO explicitly states the director is the person that implies that ambiguity.
Okay, so I want to just note a clarification, but then you're going to have to just I think you're going to have to make a decision based on the evidence you heard. One, I want to say that I believe the planning director was the very first person who testified about
Yes.
her interpretation. Okay?
Yep.
So I don't want there to be a misconception in the record that the planning director did not testify that she made a determination. Now, if you have a question about at what point that was made, that's a reflection of the evidence, and I don't have I can't comment on that, but I can say that for the record, the planning director did testify first, and Ms. Turner, and her testimony was that she made the determination. Now, if you have a question beyond at what point or procedurally, that's a question of fact that I don't believe that I can comment on, but
Okay.
I did not want there to be a misconception that there was not that testimony.
Yeah.
So you have to consider that. Now, if you have a question outstanding from what you heard about the county's process or the appellant's process, those are questions that are outstanding that weren't answered, but the hearing is closed now. So I can't go back and supplement that at this point.
Yeah, understood.
So I don't know if that clarifies that
It does.
piece. Okay. I'm trying to be careful about not getting in the weeds there, so.
I mean, Mr. Chairman, I think there's well-founded ambiguity to default positive judgment for the homeowner in this case, simply based off of the facts presented to us. Free use of real property is the default, right? The government can have so much of a say through a legislative process, which they have done, and they went out of their way to give examples, and they left tinting out. And that's my opinion.
So if I could just ask, so Shay, you went back and you kind of gave an example of why you agreed with staff. You said based on the evidence that was presented to you. Can you give a couple examples about what you said?
Yeah, so
Kind of what was kind of what gave that ambiguity and what is in support of your position, what you heard, just so I know.
When I asked the zoning enforcement officer who authorized the in the like to be, or window tinting to be within the in the like part of the definition of automotive repair, she said her three colleagues. I don't recall those three colleagues that she mentioned, but nowhere in the testimony did it say the director said that window tinting is falling within the like, and therefore I shall proceed with my investigation. It's kind of like they went out on their own, built a case or tried their best to build a case and presented it to the county, and then the county went after this business.
Ms. Womble, can I just clarify something about that I think would be really helpful? I know the hearing is closed.
I don't think that you can at this
Okay,
point. I mean, the
okay.
hearing is closed and the board is, I mean, they heard the testimony and they are, just like the judge or the jury has to, it's based on their recollection of the testimony. And so
Right.
at this point, no, we can't
Okay.
at this juncture, because the hearing is closed. So, that, they're on deliberation, so, but anyway.
And to add further ambiguity, the square footage mentioned, it says approximately 1289 square feet. Nobody went in there to actually measure it. I mean, we can't use the words approximately in evidence and have it not be true. It's perjury, right? So, based off of these facts, that's my opinion.
I'm tending to agree with you almost 100%, only because of the way it was all done. The pictures, the little video that's mentioned, which wasn't presented here, but.
And can't be considered,
Right,
because it was not included.
correct. But it seems like I have a problem with "and like." To me, it shouldn't be there at all. You have rules. I'm a banker for 45 years. We had rules. We never said, and anything else we want to throw in there. That's what that looks like to me. It's an open-ended, and we can throw anything in that bucket that we feel like if we don't want that business around. And yes, there's going to be some businesses that shouldn't be open because they're messy and what have you. But he's got a nice, clean run shop. It's quiet. We've heard that. And I don't see why we should shut it down.
So
He knows he has to do things to be in compliant, apply for permits, etc. now. And that's okay.
So just in regards to the board and what you have to consider, so you may not like the language in the UDO and the like, but you are bound by it because that is the law by which you have to review a decision.
Mm-hmm.
That being said, if you can, make sure you explain the reasoning behind your decision, because you are bound by that language.
Okay.
So if you have reasoning to, for your decision to say you agree with Mr. Hazlitt, then you need to tell us why. I think one of the things you said were you weren't swayed by the pictures and video.
Mm-hmm.
Okay, and so if you have more reasons, if you can explain those, because you are bound by using the language and the like, and the
Okay.
county can go through and make an interpretation. All those things are legal steps for them to take. So if your decision is that you don't agree with staff, then I need you to tell me why,
Okay.
in accordance with the ordinance.
All right. When I looked up for meanings of what an auto repair shop was, I actually
And the
found
evidence that was presented to you tonight.
No, I know. I'm just.
Knowledge.
There was the Federal Bureau of Auto Repair. It's a government agency. I couldn't believe it, but they gave me a definition. Exactly.
All right, hold on.
What we got there.
I want to stop you just for a second because I do not want to muddy the record.
Okay.
And you can only consider the evidence that was presented to you tonight. So if you went and looked up a definition in preparation for tonight's meeting, then you cannot consider it.
Okay.
And you cannot talk about it because it's not part of the record.
Okay.
It wasn't introduced in the evidence. And I know it sounds like I'm being a real stickler, but I am, and I've said this before, I am the traffic cop. And good, bad, or ugly, I'm trying to make sure we are staying within our lanes of what we can do. So now
We had, and I don't remember the gentleman's name, who is an auto repair man.
Okay.
And what he said was exactly what the repair is. It's diagnostics, it's making sure that the car is safe on the road, etc. And this business isn't doing that.
Okay.
Now, when you say and the like should have been a listing of some other, besides auto repair, it needs to have another noun listing with it. And then you can say, okay, we can broaden it out from there. One, just auto repair, it's not proper English.
Well, I understand, but that's the ordinance, but, and so, I mean, it's clear from your statements, you don't agree that window tinting falls within the definition of automotive repair.
Right.
And the like. So, and you said that it's quiet. You said that your perspective is that it's consistent with the testimony of the
The
I
neighbor
forget
that
his
was
name.
here.
Mr. Sproul, who testified. Okay, is there anything else?
The neighbor who, her property butted up to his, and she said it was nice and clean, it was quiet,
That was Ms. Mackley.
yeah.
Okay. Thank you. I'm not trying to be difficult.
All righty. I reckon that's my turn.
Mr. Chairman?
Well, I will say, yes, there is ambiguity throughout the UDO in multiple areas, but I don't think, fortunately, they can't list every single use that exists in the world because it's constantly changing, number one. There is a procedure to determine what uses are if it's not listed as a use in the UDO, and they gave you this on section 10.17 to help you to understand how they determined what is automotive repair and the like. It tells you right in plain language for standards for interpreting unlisted uses as permitted, and the procedure above it. It tells you right here how they go about that. So we may not like the term automotive repair, but being that the interpretation of unlisted uses says that's the closest thing that exists in the current UDO that describes what the use of the property is now, then that's what we have to go by. So it's not really about a choice of whether it's vague or not. The vagueness has now been removed because of the fact that the unlisted uses tells you exactly how to determine the use. And being that that has already been done, it is my opinion that because the interpretation of the unlisted uses procedure has been followed and the standards for the unlisted uses are permitted, describes what those are, that takes the ambiguity out of the words automotive repair and the like. That's the closest thing that exists in the UDO right now. That's not to say that sometime in the future that might change, but currently that's the way it exists right now, and that's what we have to go by. So it is of my opinion, based on section 10.17 D 1 and 2, that is the interpretation of unlisted uses, that automotive repair and the like does include window tinting. We may not like that, but unfortunately that appears to be how it exists based on the procedures for determining an unlisted use. And I agree with all of you that the young man has done an excellent job in his life by being guided in a positive way, starting the business at age 15, and 6 years later he's still rolling with it, and he's doing right. So that's not normal what you hear nowadays for folks that are as young an age as he is and they're prospering well. So congratulations on that. Any other comments about your positioning?
Well, since I'm going first, I'm going to go again. Again, the NOV was based on an interpretation. You say they're listed, but the procedure is that they interpret. Now, I think our question is, was that interpretation correct, or should it apply in this particular situation? And I for one say we should not.
And the interpretation occurs when they follow the procedure about unlisted uses. You know, whether we agree with the interpretation or not, that's a different story. But as far as the procedure by coming to that point,
Which is
Well-
why,
you know,
Legally, so I don't want to, again, I'm not going to get into the facts, I'm not going to get into the argument, but I don't want you to misapply the ordinance. You, as the Board of Adjustment, have the same authority when it comes to an interpretation, when it's been appealed to, as the planning director, meaning, you know, one, did they apply? That's why let me scroll, I'm busy taking notes and I'm listening to you, so let me scroll back up to the section I have this saved. That's why the section in the ordinance says, did the decision maker did not make an error or correctly apply the standards of the ordinance in making the decision or interpretation. And then that they made an error in determining whether a standard was met. And so you have all the authority of and there's the other ones, the decision maker made the decision based on the standard, you go through, but you do have the authority to say, you know, because it could be that staff followed the entire process and made their determination and you disagree with that. So you are able to disagree with staff's interpretation. So one of the questions is, did they follow the procedure, right? And then after that, did they make a determination based on the procedure? And do you agree with that interpretation? So you can answer that question one way or the other.
so in essence, it's our interpretation.
That's right. When a determination comes before you, and this NOV is based on a determination, right? Staff's determination, I'm sorry,
Yeah.
interpretation, and the determination basically that this window tinting business, it falls within the definition of automotive repair and the like. That's staff's determination. And I know I'm paraphrasing that a little bit, so I don't want to speak out of term, but they made that determination. And because they made that determination, they say that this use is not a home occupation, okay? So before you, yes, you have the question, did the county follow the procedure? And then do you agree with their conclusion at the end of the procedure?
interpretation.
That's right. It may be that you don't. It may be that you believe that you do because they followed the procedure. But you're not precluded from answering that question in either way.
Okay, thank you. Any other comments, discussion by the board?
Well, if we're going by procedure, it clearly says the director determines, and that didn't happen. Right, she said her colleagues. So that they didn't follow the direct procedure.
Ms. Turner is the director and she testified first. So if there's a question about, and she testified that she made the determination. Now, if you have a question about when that determination was made or how it was made, those are factual questions that I cannot.
Yeah, and that's,
Okay, I thought.
And the final
I
determination.
remember it incorrectly then.
Yeah, the final determination may have occurred after the enforcement officer was talking with other planners, discussing it. That may have happened afterwards.
Because I thought she said that it was her colleagues that had done it. Okay.
That was at the point of at the first NOV, I believe.
There's no reason the director can't ask for opinions of the colleagues.
Oh, yeah, for sure.
Okay.
But the procedure is there, and it says the director.
Well, and
Yeah,
she testified, so she obviously
She
eventually made the decision.
correct.
I mean, if we were to use this as a test, right? This 1017 paragraph 2, right? As far as interpreting unlisted uses as permitted, did the county adequately prove that their logic was sound using this checklist here. Understand it says unlisted use including but not limited to the following. So again, ambiguity is there. But the volume and type of sales, retail, wholesale, et cetera, the size and type of items sold, nature of inventory on premises. Yeah. I don't know if my question makes sense, but again, the burden's on the county, right, to prove this? Ms. Womble?
I'm sorry.
The burden's on the county, right?
So the burden's on the county to support their determination.
Okay.
And so they gave you the basis for their determination and the, that they utilized and the reasoning for the determination. And so, yes, I mean, the county has the burden of showing you that the basis for their interpretation. And so, you know, again, the board, you have the ability to agree with the interpretation, disagree with the interpretation. We kind of talked about this earlier when Mr. Schilling was making his motion. You can say, well, I agree with the interpretation, but for these reasons. I don't agree with the interpretation because of these reasons. And I think that, and I think you guys are getting a little hung up on procedure versus, like, did they follow the procedure and is there the interpretation? And you don't necessarily have to decide those separately. You can just, you know, they can be decided together, but you ultimately have to, I guess, in summary, decide if you agree with the county's position and their interpretation, which is the basis of the NOV.
I mean, if the appellant's
Or
lawyer,
the appellant's position.
if the appellant's lawyer didn't come out and directly say, yes, he's running a temp business, there's no way the county's evidence could prove that he's actually running a temp business, in my opinion. There's absolutely no way. The pictures, all that,
That's not the point, though. I mean, they've admitted what the business is.
they did, but that's to my point, right?
The point is that window tinting, auto window tinting is not specifically covered in the UDO. Therefore, it was subject to an interpretation, director and staff. And that's our simple, to me, that's our simple decision.
Yeah.
Was that interpretation correct? Do we agree with it, whether it was correct? I'm sure they thought it was correct. Do we agree with that?
Yes.
I can redo mine if that helps. I agree with staff's interpretation and determination. And my reason is that I believe and the like also applies with her interpretation and with car wash and auto detailing as an additional.
But that's not what they presented as their evidence. They presented automotive repair.
Yeah,
They
they did.
presented this chart right here that has it on it.
Yeah, that was vehicle sales and services light in this section here.
And it's also a commercial use in a residential area. I'm a planning and zoning guy, and I have to stick with that.
Any other comments from anyone?
Like vote.
Are you all ready to make a motion?
Somebody has to make a motion.
I make a motion that within our appeal review standards, that we adopt section D, the decision maker made an error in applying a standard or measuring a standard.
I'll second.
Is there any discussion about this particular motion?
Anything in addition to what you already did? I mean, is everyone just restating your previous deliberation in regards to this motion, or do you have anything additional? You don't have to go back through it.
Any other comments in addition? Any other comments in addition to what we've already talked about? How about you guys? Any other
I made the
comments?
motion, so I'm
All right.
good.
Okay, in that case, we'll go ahead and make a vote. All in favor to his motion to D, that the decision maker made an error, signify by saying aye.
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 All those opposed, nay. Nay. The ayes have it, 3-2. Pardon me?
Who?
I was a nay, he was a nay.
And Shay was a nay.
So it's the determination of this board that, that staff, the decision maker made an error based on the vote of 3-2.
And
Which is it?
I guess specificity made an error in that, I guess, just for clarification for the record, was that, I think we all kind of assumed it, but was that in regards to that the appellant's use does not qualify as automotive repair and the like?
That's what I did.
Right.
Yeah, okay. I just want clarification. And then, so, Mr. Haslett, you seconded that. Was that the motion you were, was that your understanding of the motion?
Yes, it was.
Okay, Ms. Bontemps, you voted in favor of that motion, just for clarification. And you two also continue to be nays?
Nay and nay.
Okay. Apologize. I want to just make sure for the record we were clear on what that decision was. All right.
Any other?
That's all the new business. We will need to have a order prepared, and the board does have to review it. And 160D does require that the entire board review and approve it. So we will need to do that. And I guess we'll either do it by, do you want to see if we can agree on a version? And if we agree on a version, then will everyone stipulate the board chair can sign it if the three attorneys can agree?
I like that idea. Yeah, fine with that.
Is there any objection to that?
No, no
Okay.
objection.
So we'll does the board have any objection to if the attorneys are able to come to an agreement on a version, to submit it to you by email for review? And if you have no objection, we won't need to come back
Yeah.
to reconvene about the order.
Yeah, that makes sense, and I can,
Because
I can
we,
come
so,
up and
and
sign it.
frequently that sometimes, yeah, I just want to make sure.
And I don't mind coming up to sign it whenever that happens, so.
Okay,
That'll let me
I'll
know
keep
when.
you posted on that, but what we'll do is I'll endeavor to have a draft that we can agree on, and if we can, then I'll forward it to you all to review, and if you have any objection or issue, then we can all come back and we'll just talk about it there. But
Okay.
otherwise, is everyone okay if the chair signs that prepared order?
Yep, that's fine. Okay, were there any other announcements by any board members?
Nope.
Does staff have any announcements at all? All right. I'd like to ask for a motion to adjourn.
Motion.
I second it.
There's Shay and Ms. Bontemps. All in favor, say aye.
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 Aye. All opposed, nay. Motion carries. This meeting is adjourned.